Yes, Mr.
My Lord, may I be permitted to mention serial number 228, Group 6 application on the ground of urgency.
Serial number?
Serial number 228 of the combined monthly list.
We are taking up Group 6 applications.
My Lord, I am mentioning for the urgency. My Lord, that
Where is
my
your
Lord, I am
notice to the-
apprehending that any time I may face the purported order of removal from service.
Purported order of?
Removal from service. Because they have started full-fledged inquiry.
Give a
proceedings.
notice to your other side and
Yes,
come.
yes, I have given notice to the.
Where is the notice?
My Lord,
Where is your notice?
this is the.
দাও কোম্পানি লিস্টটা দাও তো এখানে শুনতে আসে না Was it hard by us?
No, no,
It's a new application.
new application.
You want to get a... Keep a watch. Let us see when do we place. Keep a watch on our list. We shall consider.
My Lord, if it is not reached, my Lord,
Wait for this day, Mr. Mojumdar. Let us ascertain. Let us ascertain. Then we will place it in the list.
My Lord, may I have your Lordship's kind indulgence to mention, my Lord, under exceptional circumstances, principal of a college has been removed on the very first day of the writ petition. My Lord, my matter has been assigned before your Lordship yesterday afternoon, after the matter was released by the 3 honorable division bench of our court. My Lord, to be candid to your Lordship, I should take the names which are involved.
No, no, not required.
My Lord, perhaps by which the matter has been released. My Lord,
Has the file come?
my Lord, file has come. My Lord, on the very first day of the writ petition, without any affidavit.
Who is your other side?
My Lord, I am mentioning upon notice.
You are for the
Writ petitioner, respondent.
And I have given notice to the learned state advocate, to the College Service Commission, and the other parties. My Lord, I have given notice.
what is the urgency, sir?
My Lord, she has been removed. Now her principal's room are being broken open. My Lord, on the very first day, the Honorable Single Judge, without having any determination, I will.
What is the urgency?
Well,
She has been removed.
She has been removed.
Then
My Lord,
what is the urgency?
her room is being broken open. My Lord, kindly hear me.
Was the writ petition heard?
My Lord, 5th October.
5th October.
5th October, on the very next day, 6th October.
When is the returnable date before his?
My Lord, every day the matter is being heard. Every day some or other orders are being passed. I am not being able to appear.
Assigned হয়েছে আমাদের কাছে. Has it been placed before?
Max 2009.
কি জয়ন্ত কোনো assigned হয়েছে নাকি?
My Lord, it has been assigned. I am not being able to appear, my Lord. I was referred to Bar Council since I prayed for an order of affidavit. My Lord, that part of the order has been set aside.
Yes.
Matter has been marked part heard, despite I raised objection.
So it was the division bench has set aside the order.
My Lord, only the part whereby my
Why didn't you go to that division bench?
My Lord, we went to that division bench. That was the regular division bench, but because of a particular name, my Lord, the Honorable Division Bench, presided over by Justice Shen, has been. My Lord, kindly allow me to come. Kindly publish a supplementary list, my Lord. Kindly allow me to come back.
Will be there tomorrow.
My Lord, this matter is fixed today again at 3 p.m. And we apprehend now a warrant will be issued against me. We have sufficient, my Lord. If I cannot satisfy your Lordship with regard to the urgency, my Lord, will be.
Sir, what do you say?
Your Lordship.
Special officer is not circulating the report to us.
Who is the special officer?
The learned state advocate, who was earlier appearing on behalf of some adversary advocates.
So what has been fixed? Writ petition has been
Writ
fixed.
petition has been fixed by Lord by an honorable single judge, my Lord, who does not have determination.
Now it is returnable today before the single judge.
Yes,
When did you file the appeal?
my lord, 6th October.
6th of
See, I tell your lordship, 6th October we filed, 7th, 8th, Saturday, Sunday, 9th, it was released first by the courtroom number 8, assigned before courtroom number 4, released.
So what did the single judge do thereafter? When it was released, the matter must have been before his lordship. On 6th October, the order was passed. The matter must have been there on 7th also.
My lord, 7th and 8th, Saturday, Sunday. 6th October,
9th it appeared.
writ petition is being taken up on regularly.
So 9th it was taken up or not?
Writ petition,
Huh?
yes.
Then what happened?
My lord, yesterday it was directed, although the order has not yet been served. My lord, yesterday it was directed to break open my room. My lord, I am led by Mr. Sharma.
We keep it tomorrow, Mr. Sharma.
Lord, it needs immediate hearing. We have challenged the first order. The very first order at the very motion stage, I have been removed. As a principal, I am more than 20 years.
You are apprehending. Tomorrow it will be there.
Apprehending, thereafter one after another order is passed. Now today has been yesterday has been directed my lock of my office room to be broken by a special officer.
When,
But I have papers also.
when will it be broken?
Today, see, Lord, I do not request anything. Kindly see the nature and character of the order.
No, he mentioned it. We were the
Lord, may I invoke one request, your lordship?
of keeping it
Lord,
tomorrow.
publish a direct a publication of supplementary list and get it done.
Lord, I am appearing for the writ petitioner respondent. I informed the honorable single judge yesterday, my lord, it's recorded in the last order made by his lordship. That, my lord, an appeal has been carried from your lordship's order of 5th. My lord, in fact, I requested the bench, my lord, not to pass any order. Apart from, my lord, ancillary orders, my lord, in effect, not to give effect to that. My lord, he has not taken up the main issue. He has kept it for today at 3 p.m. So your lordship may keep it
Orders-
anytime subject to your lordship's gracious
Orders are
consent.
being passed, my lord.
Yes, and I told the honorable court, my lord, that we do not want to face a situation where the division bench will arrest all
My
proceedings.
lord, we have been taught like this: if an appeal is preferred against an order, my lord, normally the learned single judge stays his or her hand until, my lord, the matter, unless we suffer from latches. That's the traditional procedure followed by the court.
অর্ডারটা কোথায়? কবে কেন অর্ডার বল?
রেখে দিচ্ছি। এটা সাপ্লি লিস্ট পাবলিশ করে এসছে মা ফাইল এসছে
অসুবিধা হয়ে যাবে। অসুবিধা নেই। ফিস চলে গেলে এই যে সাবজেক্ট নাম্বার কিছুই বলছি
এসেছে কল্লোলকে বলবে একটা সাপ্লি লিস্ট কাম ব্যাক এট 2 p.m. Come back at 2 p.m. The list.
My lord, if your lordships, my lord, my learned friend has little difficulty, 12:30 is possible for your lordships.
No, the list cannot be published, no, Mr. Sharma. It will be sent to the registrar for publication of the list.
Well, I informed all the parties that your lordship would
Please
take.
inform
Come on.
from the parties.
Yes. Much.
Great.
Yes.
may I?
Acha, at 2 p.m. my sister has another bench. So, but that hopefully that will not take much time.
No, no.
Thereafter the matter will be taken.
12:30 would it be very difficult?
12:30, Mr. Bhattacharya, ki list.
Yes, yes, 12:30 মানে লিস্ট হয়ে যাবে। Very good. No, 2. I mean,
Yes, yes.
under very, this is not this mentioning, another mention.
ঠিক আছে তো এই ঘরে খুচরো কাজ শেষ করে। Yes,
Kindly
But what-
pardons me, my lord, for disturbing your lordship, my lord, this side of the vacation. My lord,
Here to be disturbed, what can be done? Yes.
my lord, one matter, my lord, an appeal has been preferred by Shaha Institute of Nuclear Physics. My lord, there was no stay granted by the Honorable Division Bench. My lord, I moved the contempt court. The contempt court has taken, not the Honorable Division Bench intended that the matter appear in the appropriate course, my lord, within the first few matters, my lord, and thereafter the matter has not appeared for whatever reasons. Now, my lord, the writ petitioner concerned, my lord, despite the order of the Honorable Single Judge, my lord, effecting a revision of her pay, of his pay, my lord, is not.
You want?
My lord, I want the matter to be listed, my lord, on any day convenient to the court for just this clarification, because the contempt court has fixed the matter.
Is it in motion stage or
No.
it was hard and fixed?
Hard and fixed.
Then how can? It's a
No, hard and fixed means it's a hearing matter. My lord,
Hearing
determination is by before my lord.
hearing matter we have
My lord, may I most humbly.
mentioned. You mentioned yesterday. Yes. When you
No,
heard, he mentioned. I
not this
said,
one.
Another matter, my lord. I mentioned yesterday this
so
matter.
what is the chief?
My lord, may it
Why
appear
this
in the
thing?
in the monthly list of November, at least fairly.
Yes, that it will appear. Yeah, no. Yes.
Oh, actually, the monthly list of November, I'm told, is already out. My lord, may it appear on the
Monthly list of November, we have not yet received that any information that there will be.
what
no
I was humbly
publication.
requesting your lordship, my lord, on the day of reopening, 16th, 17th, any day convenient to your lordship, my lord.
You means remind us on the reopening.
As your lordship.
Yes.
My lord, may I pray for leave to file this appeal
When
without
was
such.
the order passed?
My lord, the order passed on 22nd August. Thereafter, I applied for. My lord, my learned, my law clerk had misplaced that. Then again, my lord, prior to vacation, my lord,
Yeah.
deep down.
Yes.
My lord, in this matter, my lord, yesterday I mentioned, my lord, all the respondents, my lord, above 70 years and some of them have died. My lord.
Sir,
My
you
lord,
do
my
not
lord, kindly
understand.
allow me 1 minute. My lord. I will pray only filing for exchange of affidavits. My lord. I will take only 1 minute time. Like any day, my lord.
Filing of
Exchange affidavits, my lord. My lord, this matter has been admitted, my lord, by the another court, my lord.
uh,
My lord, no direction for filing affidavit. My lord.
when was it made returnable?
My lord, long ago it was hard. This
Then
matter.
why you are mentioning, sir? It
But-
way you also know that you have not taken steps.
Yes, my lord.
You remind us on the reopening, we will place the matter.
My lord, all the respondents, my lord, more than age of 70, more than 70, all are citizens.
That you
Some-
realize today.
No, my lord, yesterday I mentioned.
Realize you have been briefed just now.
No, my lord.
Then
Right.
they give us the urgency. You did not mention prior to the combined list. We could have included in the combined list.
My lord, may I be,
On the reopening, my lord, I mentioned deeply obliged.
my lord, may I be permitted to mention one matter, your lordship, this matter?
Give the slip. Give the slip. এই জয়ন্ত যদি নভেম্বরের combined list বেরোয় তাহলে ওটা ঢুকিয়ে আদারওয়াইজ ও মেনশন ইয়েস
My lord, this matter, my lord, may I be permitted to mention one matter, your lordship? My lord, this matter was running in the monthly list.
then
Yes,
what
my
is your
I am
problem?
praying for abrogation, my lord. For abrogation, my lord. Hearing matter.
Listen, hearing matter, what is the item?
104.
Remind us, if it is not reached, you remind us. Yes.
My lord, this matter was running in the month list of September, your lordship, but subsequently in the month list of October, it is not appearing.
There must have been a direction. You might not have appeared.
No, my
When
lord.
it was called, you did not appear.
When it was called, I appeared, my lord, and there was a direction to serve a copy upon the respondents. I have served that. My lord, there is some urgency because the,
So when did we direct it to appear?
my lord, it was last taken on the last Monday, your lordship.
Please ascertain what order we have passed. Now we cannot include in the combined list. Combined list has been
My lord,
published.
any day a person to your
Remind
lordship.
us after vacation. Remind
My
us.
lord, the only difficulty is that they are proceeding with a contempt matter before the Central Administrative Tribunal against from the same order which we have challenged before your lordship, your lord.
When is
and-
the when
and
is
the
the
date is
of
fixed.
the contempt?
Contempt is next fixed on 15th of December, your lordship.
Then why you are worried? Yes.
If my lord indicates, then I will indicate the respondents that on such and such date the matter will appear, your lordship.
Remind us on the reopening.
You-
We will place it 15th of December.
Yes, your
We will
lordship.
hear it prior to that.
Great.
Yes, next. All the list.
But I'm for the petitioner, my lord, in this matter. My lord, this application was filed, but my lord, at the time of filing, the name of the private respondents were not there. Your lordship directed, was pleased to direct that liberty was granted to file afresh if necessary. But my lord, the difficulty is that my lord, the original copy of the order of the tribunal is with the file, my lord. If you lordship kindly allow us to take over the original order, because without that we cannot file the see, another
Mr. Ujjal Rai is appearing on
application.
behalf of the respondent, Lordship. He's on his legs over a series of fixed matter before Honorable Court number 4, Lordship.
On order of 5/8/2020, that is of the order of the landed Central Administrative Tribunal.
5/8.
5. Yes, ma'am. That is the order passed by the tribunal. 5/8/2021. At the time of filing, the original order was annexed.
Ashok, no order is being passed against him. He will withdraw this.
Yes, only
Lordship,
thing. to-
my instruction is that it may be passed, Lordship.
Records reveal that the application being, why it is COCT?
Because mine was only to expedite the matter. This application was filed because the order was passed by the tribunal long time and no order in the injunction is suffering.
COCT number is not for tribunal.
Is COCD two, madam, but COCD means my lord to only CO is filed before the standard single bench. My lord, COCD means my lord the matter, the order is
by
pending.
single bench.
Yes, my lord, the order is pending before the landed tribunal and no order has been passed.
Records reveal that the application being COCT 2 of 2023 was dismissed as withdrawn with liberty to file afresh. Records reveal that the application was by an order dated 4th of October 2023. Mr.
Shuman Chakraborty.
Mr. Chattopadhyay, learned advocate, prays for leave to prays for issuance of necessary direction upon the department to return the certified copy.
No, yes, no original order, original order.
This is the original
Yes,
certified
yes.
copy of the order dated 5th of
5/8/2021.
5th of August 2020. Office is directed to return the certified copy of the order dated such and such, passed in OA 350/1170/2021 to the learned advocate on record of the petitioner upon retaining a Xerox copy, a photostat copy of this. Yes.
Authorized, my lord.
But I am for the petition.
This is that contempt matter, Mr.
Yes, yes, well, 12 is fixed, other matter, well, southeastern.
12 তারিখ অন্য ম্যাটারগুলোর সাথে দিতে পারো।
No problem. 12 is fixed.
Fixed it on 12th. You inform your other side.
Yes.
Two matters are there. Two matters are there.
Two matters.
Item numbers.
Now, today is my one matter. This
No.
only one matter.
না দুটো এসেছে।
Yesterday another matter was there.
File পাঠানো হলো। এটা কত টাকা?
Further.
আচ্ছা 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 অলরাইট ইয়েস
Chief, in item number 3, Mr. Ujjal Rai is appearing on behalf of the petitioner, Lordship. He's on his legs at courtroom number 4 over a fixed matter, Lordship. I was humbly praying for not today.
Who is your other side?
Served.
Not today for it. Okay.
It-
I am for the petitioner, my lord. This is a case of that land loser matter. The pate is going on. Physical efficiency test is going on. Similar type matter, my lord, already passed on order. I have already served the respondent as well as Mr. Souvik Nandi. This order can be passed, my lord. And evidence service is ready, but not affirmed. In course of today, I will affirm. my lord. This is a similar matter. সব একবারে বলে দেবো।
Bring Mr. Nandi, Mr. Chatterjee.
After 2 p.m., my lord, I will bring Mr. Nandi. Or tomorrow.
No, we pass it over. If you get hold of Mr. Nandi, we will pass the similar order.
Order.
Pass over to the আমাদের কাছে ছিল মামলা against a printed order. This was hard earlier.
No, this is first time. My name is appearing in the eligible list. Only I am calling for paid post. That is at page 68. My name is appearing serial number 48. Eligible for paid.
You call me, where is Mr. Nandi?
He is coming, my his clerk is. It will be short possible.
You take to pass over to the
I got the response.
after vacation. নাকি এটা কিসের জন্য ছিল? কিন্তু
কবে দিয়েছে? কবে দিয়েছে আজকে? অফিসার
ছুটির মধ্যে পড়বে না। Next Monday.
I am for the respondent, my lord.
5.
5.
Come on Monday.
My lord, this is matter, my lord, already passed an order. This is a termination by the Banglopian has been terminated without approval of the general matter. My lord passed a similar order in earlier occasion. In Chittaranjan locomotive, that type of matter. All right, next Monday.
This is a Banglo. No, this is item number 5.
Yes.
Item number 5 is relating to, we passed an interim order.
Is that a my lord passed an interim order? That coordinate bench passed an interim order. Stay of the
What order we have passed?
yes, my lord. My lord passed
Banglopian?
yes, termination of a Banglopian without approval of the general manager. That is bad in law. And another coordinate bench.
Not this week.
Always.
Next.
Well, affidavit in opposition is ready. May I file?
You have served.
No, not sir. Yes, no.
Then we keep it after vacation and extend the
No, well, next Monday. Next Monday. Enjoying interim order.
Come on
Yes.
Monday then.
Monday.
Yes. আচ্ছা দেখি একটা অর্ডার কর। No one appears on behalf of the petitioner. একটু দাও তো।
Your Lordship, I appeal for the appellant, Your Lordship.
Yes, where are you?
5.
We have kept it on Monday. We have
Grateful.
given you a copy of the opposition. You filed the reply.
I don't have the instruction, Your Lordship, because in this
Very
matter,
good. If they have given you the copy, you use a reply immediately. So yes, next.
Grateful, Your Lordship.
Monday we are.
Grateful, Your Lordship.
No order. Yes, next.
Millet,
Yes.
6 and 7.
oh, acha. Millet, Mr. Dotto is appearing on behalf of the appellant.
Hmm.
He's stuck Millet in some court. Millet.
Not this week. Yes. You're there, Mr.
My
Mujumdar.
lord, for the
Or we
respondent.
keep it after vacation.
Your Lordship had heard it not with pension matter.
Oh,
different
Harding
bench, Your
Justice
Lordship.
Chatterjee.
Yes.
Oh. Then we keep it after vacation. Reopening date রেখে দিই. Yes. Reopening date রেখে দিই. It will be there in the list on the reopening.
My lord, Mr. Partha was appearing in this matter for Union of India. My lord, I'm praying
This
for.
for the petitioner. দেখি একটু ফাইলটা তাড়াতাড়ি দাও. What is this application? Can 3? You are there? Yes, tell us what is the matter. Can it wait till vacation? Can it wait till after vacation? Then we will keep it, huh? আচ্ছা তাহলে এইটাকে reopening date. It will be there on the reopening. Yes.
I am for the petitioner, my lord. My application for substitution, my lord. Two of the petitioners, my lord, died, my lord. Petition. There are several petitioners, my lord.
What
Two of
is
the
the
petitioners died, my lord.
What is the application?
Application number, my lord,
the নম্বরটা কত?
3, 4, and 5, my lord. There are 5 applications. 5 are pending, my lord. During pendency of the 1 and 2, my lord, two petitioners are died, my lord. Can number 3, within time. Can number 4, out of time. So, condonation of delay. Can number 5. I have served all the respondent, my lord. This is my affidavit of service, my lord.
So this can be heard by the principal bench.
Yes, ma'am.
This can be heard. Yes. Application গুলো একটু বের করে দাও ম্যাডাম একটা
আমি আছেন
3, 4, 5.
Lordship, in this matter, I am appearing for Union of India.
Substitution application.
Yes, my lord. Let it be allowed. Substitution petition and condonation of delay.
Yes.
Which are the numbers? Tell to the court officer.
Substitution petition and condonation of delay.
কেন? নতুনগুলো আসেনি?
একটা 17-তে 2017 আর দুটো 23 আর 23-এ তো 3 আর 4 ফাইলিং ডেট অফ ফাইলিং immediate.
Is this in connection with a mandamus appeal?
No, minor. WPC, the WPCT, tribunal application, central tribunal application. I am giving the date of filing of the application.
No. Come to CAN 2892.
2892, yes, my lord. Wait.
Now, who writ petitioners are, this is within time.
Within 285 within time, my lord.
This was on, date was on 24th January.
Yes, my lord.
And you filed the application when?
Yes, my lord. Within date of date, my lord, 24th January 2020, and my lord, this application was filed, my lord, on my lord 14th March 2020, my lord.
14th
March
March.
2020, my lord.
So it is within time,
Within time, my lord.
3 months.
Yes, my lord.
Now, this who expired? Birupada Biswas.
Yes, my lord.
Birupada Biswas. He was the writ petitioner number.
Writ petitioner number, my lord, writ petitioner number 5, my lord. In a cause title, my lord, Biru Padu, Biswas, my lord, disease, my lord.
Thousand 16. Wife and daughter.
Yes, ma'am.
What was the writ petition about?
Writ petition is, my lord, regarding promotion, my lord. Kindly see, my lord, I have challenged, my lord, the order passed by the tribunal, my lord, rejecting, my lord, the claim of the petitioner, my lord. Against that, my lord, your lordship, my lord, admit this writ petition, my lord. Your lordship, along with my lord, Mr. Matre, my lord, admit this writ petition, my lord.
What is? Mr. Mondol learned advocate. অন্যগুলো পেয়েছে? ক্যান 4 কি মারা গেছে? মাধব মারা গেছে 2022-এ। This is beyond time. 2022-এ মারা গেছে। ক্যান কত? ইউ ক্যানটা কত দেখেছি? তাহলে ক্যান 3-তে করো। Mr. Mondol learned advocate appearing for the petitioners.
Yes, my lord.
Submits that during pendency of the present application being WPCT number 306 of 2016, the writ petitioner number 5 had expired on 24th January 2020, leaving behind his wife and daughter, as detailed in paragraph 5 of the application. Mr. You are for Union of India.
Union of India.
Mr.
Number.
What is your
I am
name?
led by Advocate D.S. Mishra and Shani Roy Choudhury.
What is your name?
Obhirup Roy Sannal.
Huh?
Obhirup Roy Sannal. Obhirup Roy Sannal.
Mr. Roy Sannal and the advocate enters appearance on behalf of the respondents. Having heard the learned advocates appearing for the respective parties and upon considering the materials on record, we allow the instant application for substitution, detecting substitution of the names of the heirs of the petitioner number 5, comma, as mentioned in paragraph 5 of the application, as mentioned in paragraph 5 of the application, in place and stead of Virupada Bishwas. We allow the instant application for substitute. The names of the heirs of the deceased petitioner number 5, comma, as mentioned in paragraph 5 of the application. কি বলেছে সেটা? Direct substitution of the names of the তাহলে মেনশন অ্যাজ, তাহলে উপরে বিরূপদটা কেটে দাও। The office is directed to take necessary steps the application being এত is disposed of. ঠিক আছে, আর যে দুটো আছে দেখে নেবে কোনটায় ডিলে আছে, সেটা আপন কন্ডোনিং দি ডিলে দেখিয়ে দিই বাবা। This was এটা ক্যান কত হলো? এটা বিল কত? তারপর 4টা কত? Can 4 who
Yes, ma'am.
expired?
Petitioner of 4 my lord. Died on my lord 6 December 2022.
কোনটাতে ডেথ হচ্ছে 6 ডিসেম্বর 2022। তাহলে এটা লিখবে having heard standard advocates appearing for the respective parties and upon considering the materials on record, you did not pray for condonation of delay also.
Next, here my lord 5 my lord. Can number 5 my lord.
এটা পড়েও তো ডিলে হয়েছে।
Can number
6 December 2022 she in can this
can number 5 my lord I pray my lord.
ও আচ্ছা, না বললো separate application file করেছে, but condonation of delay you have filed separate application.
Yes my lord.
In connection with
This can number 4 my lord. Can number 4.
where is that application? That is can 5.
5 can 5 my lord.
Oh baba, 188 days delay.
Yes my lord.
Where is you stated? What is the explanation you have given?
The
That's it, 20. COVID এর পরে তো 16th of December 2020. Having artisan concept materials on record, we are satisfied with the explanation given towards the delay in filing the substitution application being can এত করে দেবে, হ্যাঁ? Accordingly, the application for condonation of accordingly the delay is condoned and the application being such and such is disposed of. Stop. We upon considering the averments made in the next application for substitution, we allow the instant application for substitution, directing substitution of the names of the heirs as mentioned in paragraph such and such of the application in place and stead of the deceased. Who is the
4, my lord. Petitioner number 4. His son, my lord, 2 sons, my lord.
in place and stead of the deceased? নামটা কি? মাধব চন্দ্র কর্মকার। Application here is disposed of. So, office is directed to effect necessary correction. ইন্দ্রাইও পাঠিয়ে দিও।
Yes, my lord.
Post title গুলো দিয়ে একটু চেক করে নিন। আর 3টে application. And what are the other 2 applications?
Other 2 application, one for my lord, expeditious disposal of the matter, my lord, and another for production of the original document by the defendant, my lord, before the court, my lord. So, my lord, the 2 application, your lordship fix the
Affidavits have been exchanged.
no, my
So it is in motion stage.
lord. Motion state.
Till date motion stage.
My lord, your lordship admit that, my lord, thereafter matter was not appeared.
When did we admit the
Yes, ma'am.
which is your application for expeditious hearing?
Expeditious, my lord,
একটু ফাইলটা দিতে হবে। ওই expeditious hearing এর application।
1, my lord,
What is the number of your expeditious application?
2017, my lord, 11345, my lord. হ্যাঁ, পুরনো 11354 11354
Order sheet না অর্ডার হয়েছে তো কি বলেছি? An RBO has been made out. আচ্ছা দেখি আর অ্যাপ্লিকেশনটা বের করতে হবে expeditious hearing. What is the number of application for expeditious hearing?
sorry, my lord, can number 3844 of 2017. 3844 of 2017. This is the affidavit of service, my lord.
ঠিক আছে আর মেইন পিটিশনটা WPC ডিসিশন দিচ্ছে সেটা আপনি
In the original application, reply rejoinder are exchanged.
No, they have not filed anything. Till date, they have not filed anything.
You have not filed.
Lordship, this is a new brief for us.
Pardon?
This is a new brief for us, Lordship. We will have to take instructions.
আচ্ছা লিখে দাও এটাতে ক্যান নাম্বারটা বসিয়ে দিও। Records reveal that the writ petition was admitted on 21st of February 2017. and is pending since then. The learned next okay. So Mr. Abdul Learned Advocate appearing for the petitioner submits that the
21st February 2017, my lord. Your lordship admit this. my lord.
was admitted by by an order dated 21st February 2017 and is pending since then. And accordingly, the application has been referred for early hearing. Upon hearing the learned advocates, this the matter for final hearing in the combined month at the learned advocates. আর ওনার নামটা দিয়ে দেবে ইন্টারসেপ্টেড at the learned advocates. Please next one is the matter for final hearing in the combined month of December 2023. Stop. The parties would be at liberty to exchange their affidavits. Their affidavits and the executive must indicate parties would be at liberty. The application being is disposed of. What is the other
Other application, my lord, permitting my lord to produce my lord the documents, my lord, additional documents, which are subsequently that can number my lord 11354, my lord.
What original document you got?
My lord, that all documents I have annexed, my lord. Thereafter, my lord, subsequent all documents, my lord, I have recovered, my lord. That documents are not produced before the tribunal, my lord.
So this application you have filed, now it has come on record.
Yes, my lord.
So give a copy to your friend.
Yes.
Have you served?
I have already served my lord affidavit of service.
When did you file that application?
Application
we have
was
not-
for 2017, my
We
lord.
have not received anything from the ministry.
Ministry is
All
received.
right, it will be in the December, you serve in the meantime.
Yes, my lord.
ওটা ছেড়ে দাও, order করতে হবে। শুধু একটা
Yes.
along with
Yes.
that application list করে দেবে, combined list. December. Yes, next.
My lord, affidavit of service in the both.
করে দিয়ে দিও affidavit. একটু চেক করে দিও আর কি।
নাম দিয়ে দিয়েছি।
তো, একটু স্টেটমেন্ট গুলো চেক করে দিও। Yes, next. জীবিত লোককে আনা হলো।
আমি তো অ্যাপিলেন্ট এই রে তুমি আমাকে তো স্ট্যাম্প মেরেছো ঠিক আছে স্ট্যাম্প মাঝে মাঝে তো টেস্ট বদলাতে হয় তবে আমার এই স্ট্যাম্পটা বেশি দিন নয় তো 8-9 বছরে গরম কোথায় গেছে আগে ছুটতে হবে উইল টুইল দেখতে হবে বলতে
Yes,
my lord this is my appeal my lord
item.
but item
10.
10 my lord my humble submission my lord I am led by Advocate General it will take some time my lord if you lordship kindly take it my lord after vacation then my lord let us
Combined list December.
my lord it will take some time my lord
My lord, kindly consider, my lord, the heading. It is a fixed matter and my lord kindly consider the last order. My lord had recorded why it was placed under the fixed matter.
Right.
Because these are, my lord, all pre-1996.
What did we say? Why
My
you
lord-
traveling, Mr. Sen?
No, my lord, otherwise kindly, my lord, Taxi, my lord, I have never troubled him. Only this issue because, yes. My lord, regarding litigation, my lord, I am very much,
আমি টাইম নেবো না এটা ছুটির আগে শেষ হবে না
না, ওটা ফিক্স ম্যাটারে থাক।
ইটস এ ভেরি বিগ ম্যাটার ছুটির আগে শেষ হবে
না, আমি ছুটির আগে আপনি করবেন না, আমি করতে বলছি না আপনাকে। কিন্তু all NBST, I'm sorry.
না না না, না সব্যসাচী স্টেটের হয়ে নয় সব্যসাচী এনবিএসটিসির হয়ে হ্যাঁ আমি স্টেটের হয়ে সব্যসাচী এনবিএসটিসির হয়ে অ্যাপিয়ার করছে আমি স্টেটের হয়ে অ্যাপিল
We are not passing any order, it will appear in the supply list of the date of reopening.
Well, 1 week after vacation, Lordship. 1 week?
It appear, Mr. Sen,
My lord.
otherwise if it is to be sent down in the.
I see. Very good.
Let it be retained in the list, it will appear on.
My
that.
lord.
And if you have problem on that. then-
My lord. Grateful.
Because it is a pensionary benefit, all my lord NBSTC pensioners. That's why I have made that prayer. My
We have not disturbed this.
Yes, I'm grateful.
Appear.
I'm grateful.
Yes, next.
Good.
Mr. Sen, you are to finish it.
My lord.
You are competent enough to ask.
My lord. In
But wait for the advocate, and he might be busy in other.
My
You are to and yes.
Reopening supplementary. Reopening
Has
is supplementary.
Mr. Nandi.
জানো তো, supplementary to be-
Go to see the for item 4, I am extremely sorry, my lord. I tender my unconditional apology for not being present when the matter was called.
You are passing that same order, Mr.
Yes, my lord, kindly also record that being instructed, one of the, he has been eligible for paid. So paid will be conducted on, my lord, 15th October. He will be informed in due course. And the same order as passed by your lordship in earlier occasions.
So he would be sent for medical. exam.
Yes, after conducting paid, my lord, let him participate in the paid, then medical.
That is what we give a copy to Mr. Nondi. That
He has already given.
that we have recorded, Mr. Nondi. Last paragraph, further sir, after completion of paid, the successful candidate would be sent for medical examination as expeditiously as possible.
Lordship.
That is already there.
Yes, this order may be possible.
এইটাতে না এই মিস্টার বাসুটা কিছু নাম দিয়ে দিল মিস্টার Do you have a copy of that instruction?
No, no matter today or also, my lord, I'm,
Let me read the instruction.
my engagement also not been regularized. Just now I received the piece, my lord, kindly pass one online water. My lord.
You remind us on the next day, we will regularize because we have already stated you are appearing for the respondents. You are not engaged in this.
No, because yesterday afternoon, we have received brief. So therefore, there are certain formalities has to be completed by my client.
So can we record that you are appeared?
Yes, I have received instructions to appear.
Then we will, if it is not regularized, you mention it on the next day, we will regularize.
Very well, as your lordship.
And this is the affidavit of service. Let it be kept.
পুরো affidavit of service file. Remaining portionটা same. এই portion.
Okay,
You remind us if not regular.
very, I shall be grateful to you. Now for-
Right. Yes, your lordship, I am appearing for the appellant. My lord, on the last occasion when the matter was heard, your lordship has been pleased to direct my learned friends, my lord, vacating application to be treated as opposition and to file a reply. My lord, I am filing the reply only by mistake. In spite of, instead of reply, it has been mentioned as opposition. So as it has been affirmed, your lordship, kindly pardon me for that. I am filing this. And I am serving my learned friends. It is George have a copy. It will be actually reply, but wrongly,
What are the applications?
the application he filed, I am serving my learned friend.
I filed an
Yeah.
application for vacating of ex parte
Application-
interim order, my lord.
For
This
vacating
was out of employment,
order,
reinstatement order was
just a
given
minute.
during the
COVID period.
Mr. Mohabbat, please wait, let us hear.
My lord, he has filed an application for,
The Can 1 is your stay application.
yes,
So
Yes.
Can 2 is your,
my lord, that early hearing, that was disposed of.
Can 2 disposed of.
Yes. Now,
No, early hearing was Can 3, that was disposed.
yes,
Then Can, what is Can 2?
can two take.
Oh, Can 2 has been disposed of earlier. So Can 1 is the only application. So what is Can 1? Can 4 হচ্ছে vacating application. Your vacating application is Can-
My lord. Yes, one is stay, another, I'm grateful to your lordship, my lord. That is section 5 application.
which one?
My lord,
Can
here,
1.
yes, my lord, here can 2. Can 2 is section 5 application, that
has
is
been
can
disposed.
number
So
49.
Can 1 is your stay application.
Yes,
To that you have obtained an interim order, he has filed a vacating.
yes,
That application is still pending.
yes.
Your
And
Can 1 was disposed of or it was an interim order granted?
no, it was not disposed of, it was filed, it was, interim order was still disposal of the appeal, subject to correction from your lordship. If your lordship kindly sees the order dated September 10, 2020, passed by the Honorable Justice Banerjee with Justice Roy,
September 10th.
September, my lord, 10, yes, 2020. The appellants, second page, the appellants need not give further effect to the order impugned dated February 1, 12, 2020 till disposal of the appeal or earlier order in this appeal. The appellants will immediately inform the writ petition of this order. That has been done. And
So what interim order did you obtain?
my lord, not to
Order
give effect,
impugned was state.
yes,
Order impugned was 12 February 2020.
memo of appeal to the, yes, wherein my lord, I'm placing the
mandamus appeal.
mandamus appeal against the order of the Honorable Justice Sinha, where his lordship has been pleased to set aside the disciplinary order, authorities order, appellate and revising order, and directed to reinstate the petitioner in service immediately and to pay all consequential benefits to him as entitled in law by treating him in service at the earliest but positively within a period of 4 months from the date of communication of the order.
Did you prefer any content?
No, my lord, since there was a stay, my lord. And your lordship,
So,
So-
it has to be hard finally.
yes, finally, and so far the vacate.
On the last occasion, your lordship was
Just
to
a minute,
direct me
sir,
to place the
just a minute,
document.
sir.
Your lordship will hear the matter. My lord.
Yes, your lordship,
I-
vacation heard the matter. So far vacating of the interim order application by my learned senior friend, if your lordship kindly comes to his.
Argu, this is the
No, I am ready with the
Yes,
final hearing.
please.
Your lordship kindly fix a date.
Yes, we are ready today. You argue.
My lord.
Yes, yes. I'm arguing. Judgment below that. Your lordship, may I place the order? Your lordship kindly comes to my memo of appeal. 117 it starts. কি দিচ্ছ তুমি জাজমেন্ট গুলো? আরে জাজমেন্ট গুলো আলাদা তিনটে আছে। My lord, may I place the judgment? The petitioner was a member of the Central Industrial Security Force. Pursuant to a disciplinary proceeding initiated against him, he was placed under suspension. The petitioner was served with the memorandum of charges followed by the articles of charge. Copy of the documents and a list of witnesses relied upon by the employer was provided to him. A presenting officer and an inquiry officer was appointed. A regular disciplinary proceeding was held. CSF এর বইটা আছে? জানতে বলো। Now, the disciplinary authority, after going through the documents, my lord, I'm here pausing here for a moment. My lord, what is the charge? I'm putting the question to myself. The charge was that, my lord, during the duty hours, in short, I'm submitting, during the duty hours, these personnel.
So we will listen to you. Let us.
Yes, I'm reading. I'm placing the entire judgment. Thereafter, I will. The
Regular
disciplinary authority,
proceeding was
after going through the documents and after perusal of the depositions, came to the conclusion
Or
Then
Mr. Mitro, you give us 5 minutes. Let us go through the.
Yes.
Then you argue.
Yes.
Yes, Mr. Mitra.
Yes. Now, my lord, two things which came up, the main points. One is that one, my lord, argument was raised by the other side was that the petitioner was not in course of his duty hours. Number one. And number two,
The petitioner was
not in course of his duty hours when the incident happened. And number two, my lord, the presenting officer was of different opinion. There was benefit of doubt that was not considered by the disciplinary authorities. Now, may I place the CISF rules, my lord, your lordship. Rule 15.
No, what can you first take us to the chart sheet?
Yes,
Where is the chart sheet? Oh, that is page 36.
I'm coming to that, my lord. Just a minute. Yes, I'm coming to that. Page 36 is the order
That is
for
page
invoking inquiry.
41
Yes,
charges.
page 30 on my memorandum charges, page 32 is the page 30 on 32. Yes, 32, your lordship. Article of charge. May I place my?
You have read it.
Yes,
Now, was any complaint lodged by the lady?
yes. So much a complaint.
No. That the allegation was he had molested her.
Yes, yes.
Did
He stated before the authorities, my lord, when the incident took place at her family quarter, immediately he rushed outside the quarter and he raises cry. And the duty personnel who was there, he immediately narrated the incident to that person. Actually, my lord, the petitioner, writ petitioner, told that he went to the ladies' quarter for taking some money as a loan. And there the lady offered him a cup of tea, knowingly that he is his colleague, one of his husband's colleague. And he started to misbehave. Now, my lord, so far, the point which has been raised that he was not in duty hours, my lord, my respectful submission, if your lordship will be rule 15. Rule 15 টা কত? We can't remember. Rule 15. Yes, may I place, my lord, your lordship? Don't
Rule
know.
15.
Rule 15, 1-5.
Do you have a book?
বইটা কি হলো?
এই বইটা আনো।
My lord, your lordship kindly takes my
We are taking Mr. Mohapatro's.
My-
Give it to you, place it. এই বইটা আনো।
office.
এটা লিখে
Of officers,
লিখুন না Central Industrial Security Force Act 1968.
rule 15 টা বের করুন, তুই 13 টা দিয়ে
তাড়াতাড়ি আনিয়ে নাও। Which provision you are placing, Mr.
My lord, officers and members of the force to be considered always on duty.
Section?
My lord, this is section 15,
1-5.
1-5. Every member of the force shall for the purpose of this act be considered to be always on duty and shall be at any time be liable to be employed at any time within or outside India. So, my lord, when he is in that area, office area, it means he is in duty. So far 15 is concerned. So he cannot exempt that I am not in duty. And this is not a case that he has opted for leave and leave has been granted to him. He is out of the native place. He has opted for leave. It is not the case.
So what was the finding of the judge as regards that issue? That was argued.
Yes,
What
the finding was that he is not in duty, my lord. May I place the relevant part
Yes,
of the
please.
judgment? Page, your lordship kindly comes to my memo of appeal, impugn judgment.
Yeah.
Yes, my lord, page is, my lord, 125, paginated, memo of the appeal. Inner page is 10. Inner page is 10, my lord, of the judgment. I am placing paragraph 3. Moreover, your lordship got, my lord?
Yes.
Moreover, the entire incident took place beyond the duty hours of the petitioner. The submission of the respondent that a member of the force is always on duty cannot be held good in the facts and circumstances of the case. The incident is also not related to the duty of the petitioner. Had the misconduct been an enumerated one directly related to the job that was to be performed by the petitioner in course of his official duty, then non-performance of the same would have been otherwise. That being so, dismissing the petitioner from service on an allegation which can be dealt with under criminal law was inappropriate. Your lordship, I am pausing here for a moment. Your lordship, kindly, your lordship, remember the assassination of Prime Minister Mrs. Gandhi's case. My lord, the law is otherwise completely different. My lord, criminal act by an individual and a criminal act in the duty of us, my lord, committed by a paramilitary force or a security officer or a militant who is supposed to the utmost dignity of this land is considered always as a heinous one. My lord, on good faith, your lordship kindly appreciate. My lord, your lordship, pardon me if I say something more. My lord, we are always talks of right to equality. My lord, a colleague went to a house of the my lord, wife of the husband.
Did he have any antecedent?
No antecedent, my lord.
This person did
No,
not have
no,
any
no,
antecedent.
no. Antecedent, my lord, earlier antecedent with this incident, no antecedent. Earlier one antecedent I remember was, my lord, he was drunken and he was moving with, my lord, the car full of these, my lord, students. That was the antecedent, if I remember correctly.
That you have brought on record.
Yes, yes, in the stay application. Yes, yes, that is there. That is there. And antecedent is there, but not with this lady. Now, here, what happened, my lord, your lordship kindly appreciate. My lord, when husband is not in the house.
Mr. Mitra, the point is
Yes.
that the disciplinary authority, upon scrutinizing everything, took a decision and imposed a punishment of
Lesser punishment.
imposed the punishment of withholding stoppage of increment.
Yes.
Now your revising authority has
Suo moto, yes.
suo moto done.
My lord, that is under the law. They can, my lord.
No, we are not saying they cannot.
Yes, yes.
Now this suo moto consideration was granted upon granting an opportunity of hearing to the
Yes,
person.
that has also been done.
What did the revising authority, what was the reason for enhancement from stoppage of one increment to dismissal?
Yes.
This becomes his argument will be this is totally disproportionate.
Yes.
What is your stand on that?
Yes.
Your argument is
proportionate.
presenting officer, whatever he has said, the authority is now bound by it.
Yes.
This is one argument.
Yes.
Next, he committed the this misconduct in
Yes.
course of his duty.
Yes, and
because
which is
terms
grave in
of
nature.
Section 15,
Yes,
he should be, discipline force should be construed to be
Yes.
in duty all over.
yes,
This is your argument.
yes.
So let us hear him and finish it off.
My lord, I have judgments also for your.
Yes, yes.
Yes. Judgment will-
On facts, you have to show us anything else?
My lord, facts, my lord, it is,
These are admitted facts.
yes, these are admitted facts.
Now, this issue of antecedent, we did not find in the judgment. It was not argued on your behalf.
That was not the requirement. That was not the requirement. My lord,
Wait, Mr. Mohapatra. You take your seat, let him complete. He's the appellant. He has a right
my lord,
to
if
be
your
here.
lordship, my lord, today, actually, very frankly, I'm submitting, I was under the impression that that application will be heard, my lord, subject to correction, my lord. I am not ready with the appeal. So if your lordship kindly, my lord, gives, my lord, at least this week's time, so that, my lord, I can answer all to your lordship's queries, antecedent, but
Becomes then
my lord, only, my lord, that is, so that I can prepare more myself, my lord.
no.
So far, argument,
Vacating application, if we vacate the interim order, you have to give effect to the order of the court.
yes, yes. My lord,
Here
it
the
is
appeal
admitted
ready.
fact. It is
We are hearing the appeal along with.
No,
this.
that's true. But if your lordship kindly, my lord, give an opportunity further, my lord, for hearing of the appeal, my lord, so that I can satisfy your lordship, my lord, any day, my lord, in the next week, any day. I am not saying after vacation, before vacation, convenient to your lordship, my lord, any day. Because I have to.
When are you retiring, Mr.
My lord, I
Mohapatra?
am opposing such prayer, my lord. After they are getting stay, let them show a single notice. They mention the matter. I shall agree with him. They don't want to.
No, we
Vacating the.
are hearing the matter.
My lord.
Your client is going to retire when?
My lord. Yes,
Sometime is there.
time is there.
Sometime is
So-
there. Presently, you are not in service.
No,
They
yes,
have
sir.
not reached it.
My lord, he was in Manipur. He's unable to stay on the last instance, my lord. Their situation is not as such. The poor.
No. Question of vacating the interim order at this stage does not occasion because we are hearing the appeal.
Kindly hear this matter. Conclude. I am a success member, sir. I can hear.
Come ready, tomorrow we finish.
Well, tomorrow I am not coming. Well, day after tomorrow, if possible.
Mr. Mitra, my sister won't be there. This
The
bench may
difficulty
be.
I have, my lord, I have a doctor's appointment tomorrow, then I have to cancel. It is up to your lordship, my lord. Any day in this week, any day. Then your lordship,
This way, Mr. Mitra, we give you advance notice. We are hearing.
no,
the
that's
matter.
true, my lord.
It was
my
incumbent
lord,
upon you. to come.
any day, my lord, if your lordship takes the matter except tomorrow.
How many working days we have?
My lord, day after tomorrow, Friday, any day, my lord. I am ready with that, my lord. Because so far facts are concerned, my lord, I want to see once. That is the reason. Argument I can do, my lord. So far, the judgments part is concerned. But what is failing from your lordship, I have to answer that the part of antecedent part has been dealt or not.
That is, we will going through the records, we will understand.
Yes.
What judgments you are.
Yes,
saying.
yes. I'm submitting.
We can, because
Yes,
we can
yes.
conclude the hearing.
Yes, I can conclude. And short written notes I can file, my lord, subject to your lordship's convenience,
Then not
Thereafter.
required.
my lord. The first one, to Joseph.
Yes.
My lord, State Bank of India and others versus Narendra Kumar Pandey. AIR SCW 2013, AIR SCW 581. I will be taking your lordship to paragraph 23 and 20 to 25 and 25. May I place, my lord, paragraph 23? My lord, here is no pagination. That is the difficulty. Your lordship kindly comes to paragraph 23. Now, so far, my lord, judicial review, appreciation of evidence, I need not, my lord, place judgment. That is a settled principles of law. The High Court, in our view, your lordship got.
Yes.
The High Court, in our view, under Article 226 of the Constitution of India, was not justified in interfering with the order of dismissal passed by the appointing authority after a full-fledged inquiry, especially when the service rules provide for an alternative remedy of appeal. It is well acceptable principles of law that the High Court, while exercising powers under Article 226 of the Constitution, does not act as an appellate authority. Of
There is
course,
no dispute as regards
yes,
this.
and
proposal.
thereafter, I am taking to your lordship to paragraph 25. cannot reappreciate the evidence. This is on that point. Next, this court in Lakshmi Devi Sugar Mills versus Pandit Ram Sharup held, where a workman intentionally refused to participate in the inquiry, cannot complain that the dismissal is against the principles of natural justice. Once the inquiry proceeded ex parte, it is not necessary for the inquiry authority to again ask the charge officer to state his defense orally or in writing. We cannot appreciate the conduct of the charge officer in this case, who did not appear before the inquiring authority and offered any explanation to the charges leveled against him, but approached the High Court stating that the principles of natural justice had been violated. Now, thereafter, I will be taking to your lordship the next judgment. My lord, AIR Supreme Court 1992 2188, State of Punjab and others, appellant versus Ram Singh ex-constable. I will be taking your lordship to paragraph 6. Rule 16.2(1) consists of two parts. The AIR Supreme Court 1992 2188. The first part is referable to grievous acts of misconduct which entails awarding an order of dismissal. Undoubtedly, there is distinction between grievous misconduct and grave misconduct.
Paragraph?
Paragraph 6. My lord, what fell from your lordship, my lord? Gravest and grave misconduct.
Yes.
Yes. Undoubtedly, there is distinction between grievous misconduct and grave misconduct. Before awarding an order of dismissal, it shall be mandatory that dismissal order should be made only when there are grievous acts of misconduct, that too when it impinges the pensionary rights of the delinquent after putting long length of service. As stated, the first part relates to grievous acts of misconduct. Under general clauses, act singular includes plural, act includes acts. The contention that there must be plurality of acts of misconduct to award dismissal is falsidious. The word act should include singular act as well. It is not the repetition of the acts complained of, but its quality, insidious effect, and gravity of situation that ensues from the offending act. The color of the gravest act must be gathered from the surrounding or attending circumstances. I am pausing here for a moment. Well, surrounding circumstances are there. My lord, beyond reasonable doubt that the person has committed the offense. Take, for instance, the delinquent that put in 29 years of continuous length of service and had unblemished record. In 38 years, he commits defalcation of public money or fabricates false record to conceal misappropriation. He only committed once. Does it mean he should not be inflicted with the punishment of dismissal, but he allowed to continue in service for that year to enable him to get his full pension? The answer is obviously no. Therefore, a single act of corruption is sufficient to award an order of dismissal under the rule as grievous act of misconduct.
Yes.
Now, the third one, my lord, I will be placing before your lordship. Can I 6, 9, 8, 7, 7. My lord, that is 1997 AIR Supreme Court 1393. Secretary to Government and others versus ACG Brito. I will be taking your lordship to paragraph.
Yes, paragraph.
Yes. 6, my lord. The third reason given by the tribunal that there was no justification of initiating a disciplinary proceeding against the respondent is also not sustainable. The proceeding was initiated against the respondent for his indisciplined conduct in disobeying a lawful order passed by his superior officer who was competent to pass such an order. The respondent was transferred from Madras to Trichy and was posted as sub-inspector in charge of Vikirmangalam police station. After joining duty, there was on 12/11/80, he proceeded on leave from 13/11/80 and continuously remained on leave till he was called upon by the superintendent of police by passing an order on 4/6/81 to appear before the medical board on Trichy on 9/6/81. as he has remaining absent on medical ground and had produced certificates from different medical officers, the superintendent of police becoming suspicious about the genuineness of the ground on which he was remaining absent had passed that order. The fact that he did not comply with that order is not disputed. His explanation that he had no money to travel from Madras to Trichy and therefore he had requested the superintendent of police on 8/6/81 to issue a railway warrant. As a railway warrant was not given to him, he could not remain present before the medical board on 9/6/81 as directed was not accepted by the concerned authorities. We will hereafter point out that there were good reasons for the authorities not to accept the said explanation. Such an act of insubordination or disobedience of an order by a police officer has to be viewed seriously as a higher degree of discipline is expected of a member belonging to the police force. Therefore, it cannot be said that there was no good and sufficient reason or a valid justification for initiating the disciplinary proceeding against him. Now, thereafter, your lordship, I will be taking your lordship to the same judgment. My lord, paragraph 9. The rules applicable in this case do not specify acts of misconduct for which a delinquent officer can be published. Rule 2 empowers the competent authorities to impose upon members of the service penalties specified therein for good and sufficient reason. Therefore, the decision of this court, my lord, that judgment was placed by now. Yes, yes, I'm grateful. My A.L. Kalra's case is clearly distinguishable. Before holding that there was no justification to initiate disciplinary proceeding against the respondent, the tribunal ought to have considered whether there was good and sufficient reason for initiating such proceedings against him. It was not at all justified in taking that view on the ground that such an act of delinquency has not been specified in the rules as an act of misconduct. Not being a legitimate order of his superior by a member of the police force has to be regarded as an act of indiscipline and would certainly provide a good and sufficient reason for initiating a disciplinary procedure. Thank you. আচ্ছা স্টের অ্যাপ্লিকেশনটা দাও স্টেট এটা একটু বসে আগের ইনসিডেন্টটা ফান করে ইনসিডেন্ট বুঝতে পারলাম ও আচ্ছা Now, my lord, the explanation here also says, my lord, the DA authority or the higher authority revision authority is not bound to accept the, my lord, what has been stated by the petitioner. My lord, the relationship with the petitioner and his colleague wife was not so close that, my lord, the explanation of going suddenly to her house for getting a loan is acceptable, my lord, by the higher authorities, my lord, in this case. Your lordship kindly appreciate that relationship was never there. And immediately that lady, after the incident, was rushing and he went to the sentry outside the quarters and narrated the incident. And he gave evidence before the authorities concerned. If your lordship wants to see the records, I can place the records. Subject to correction from your lordship, the evidence of.
Can you come to the revising
authority? Yes.
No other judgment you have, Mr. Mitro?
No, so I need not.
Show us the revisional authority.
Or yes. Just a minute. Just a minute.
Yes, page 8.
Yes, may I place one? So, order on suo motu review, page 80. Suo motu review, কোথায় আছে section এ বের করে 54 না কত? The charge memorandum was acknowledged by the charge official on
Para 3.
para 3. While reviewing the case suo motu under 54(1) of CISF rules 2001, I found that the penalty awarded to the charge official by the disciplinary authority and upheld by the appellate authority was disproportionate to the gravity of the delinquents. Therefore, a show cause notice being such and such suo motu review. Now, your lordship kindly comes to the next page. Dated 19/7/12, proposing to enhance the penalty to dismissal from service was issued. The charge official was also afforded an opportunity to submit representation, if any, in writing, if he so desired within 15 days of receipt. The charge official received the show cause notice on 27/7/12 and submitted a representation dated 10/8/12. In his representation, he raised inter alia following point: that he did not misbehave with O.I. Devi, that he visited quarter of Constable O.I. Devi to convey message to Srimati O.I. Devi as informed by Constable O.I. Singh over phone, that Srimati O.I. Devi received him at their quarter, offered him a seat and served him a cup of tea, that Srimati O.I. Devi asked him for loan of rupees. My lord, here I am pausing here for a moment. Your lordship kindly appreciate. O.I. Devi asked him for loan of rupees 2,000, that due to shortage of money he could not help her. That Srimati O.I. Devi fabricated a malafide stories to defame him for not fulfilling her demand. Wife of a constable, I'm pausing here for a moment. If she needs any amount, she will be asking the money to his husband's colleague. I'm putting the question to myself. This story, exaggerated story, was not believable by any of the authorities. That if such incident actually happened in her residence as she claimed, why did she not raise alarm for help? It is wrong, my lord. I can prove from the evidence itself she raised for help after he went outside. That she left her quarter and after properly locking the door, which she never expected after such a heinous act, that she later made a hue and cry in barrack lines to keep everything in her control. Hence, it is clear that she had masterminded for trapping him. My lord, here I am pausing here for a moment. In this case, there was no plea of the petitioner that there was ever any enmity of relationship between the petitioner or his colleagues, the husband of the O.I. Devi or wife of Devi, that she will mastermind this story to defend the petitioner. That Srimati O.I. Devi has deposed that she had not shouted because there was no one around there. That it was her presumption and not reality, which clearly indicates an abrupt or inappropriate sequence or events. In fact, at that time, Constable D.B. Deori was present in his quarter located close to her. That as per complaint of Srimati O.I. Devi, the incident occurred at about 12 hours and immediately she went to out unit line and met Constable K.J. Singh, who had been relieved from duty at about
Yes, Mr. Mitra. Now,
Now-
let us hear him.
yes, only one thing, your lordship, there is
Mr. Mitra, there are two parts of it. First was that the disciplinary proceeding was concluded,
yes,
punishment was imposed,
yes,
stoppage of increment.
yes,
Now, suo motu division, from
Yes.
stoppage of increment, it is dismissal.
yes,
Now, when he preferred the writ petition, he
Yes.
preferred challenging everything.
yes,
Now, the question is, there are two compartments.
yes,
One is, upon a regular proceeding, the man
Yes.
has been found guilty, a punishment has been imposed.
yes,
So far as the window of judicial review is concerned,
yes,
whether we will enter into that aspect or whether the learned single judge was right,
yes,
setting aside everything,
yes,
learned
Yes,
single judge
yes.
said that there is no misconduct.
yes. Learned single judge has not said, yes, yes,
So,
my lord.
as there are two parts,
I understand.
your even whether the setting aside of revisional authority,
Yes,
that order if it is to be scanned,
Yes,
whether it is recent, whether it is unknown,
yes,
then if that order is set aside,
yes.
even then the first punishment
Yes,
remains.
I'm grateful. I'm grateful to your lordship. That remains.
Yes,
And
Mr.
it just fell from your lordship, but your lordship is asking my learned senior friend, my lord, his age of retirement is in the year 2036. 36.
2036.
36 বললাম তো? Yes,
Oh,
I must. As an officer of the court, I must, my lord.
Acha, Mr. Mitra, please show us that antecedent you are saying.
Yes, my lord, let him argue. I'm finding this. Yes.
Yes, Mr.
Kindly give me 5 minutes time.
My lord, first, my lord, come to Rule 36. Rule 36 3C, my lord.
No, no, first show us in you read petition which you preferred. Did you challenge the entire proceeding? Mr. Mitra, why should we enter into the first portion of the order of the disciplinary authority? Stoppage of increment. There are two compartments.
Fine.
The learned single judge, while considering your claim, has set aside everything. Charge sheet gone, misconduct gone, everything was gone. But your argument may be that what was the reason towards enhancement of the punishment? That is one part of it. But how can the read court enter into upon reappreciating evidence, since there was a benefit of doubt given by the presenting officer that weighed with the disciplinary authority, and as such the punishment was of a lesser quantum? Why should we interfere with that? This is one reply we want from you. Second reply is, what is the wrong in the revisional authority order? He has the power under the statute to suo motu act on the basis of the. These are the two things we are interacting with you so that you can argue on that.
My lord, so who is the presenting officer? First, my lord. Who is presenting officer? Rule 36.
Rule 36. Yes, rule
36 3C, my lord. Rule 3, 5A, 5B, 5C, where the disciplinary authority itself is concerned to the article of charges or appoint.
You are reading 36(5).
C. Lord, see. Where the disciplinary authority itself inquires into the end of the article of charge or appoints an inquiring authority for holding any inquiry.
Just one moment. Mr. Mitra, take back.
My lord.
Yes, where the disciplinary authority
Itself inquires into the article of charge or appoints an inquiring authority for holding an inquiry into such charge, it may, by an order, appoint a member of the force to be known as the presenting officer to present on its behalf the case of in support of the article of charge. He is acting on behalf of the disciplinary authority. Then we'll come to section 17, 36(17). My lord.
Yes. Yes.
When the case of the disciplinary authority is closed. Most important, my lord.
disciplinary authorities case ended with the findings to give benefit of doubt, there is no result. That is the disciplinary, presenting officer case is disciplinary authorities case.
So you are saying that authorization was upon presenting officer, and on the basis of the presenting officer's view, the matter was considered and it was closed as is permitted. So
That
you
should
are
have been
saying
closed.
the presenting officer in fact is the disciplinary authority.
Rule says, my lord, sir. Rule says. That is one aspect.
That PO is in fact the DA. That is your argument.
My lord, as per the rule,
Uh-huh.
as per the statute, my lord.
Yes.
There was section 15 of the act. Officer of the force always on duty liable to be employed.
Section 15.
15 of the act,
Yes.
where member of the force shall, for the purpose of the act, be considered to be always on duty and shall at any time be liable to complain interface. Well, the purpose of the act is, my lord, when a petitioner is not on duty, in case of emergency, he may be called for duty. It does not necessarily mean that 24 hours he is within the duty. That is not. But suppose one is deployed for 8 hours duty. Well, for example, I'm somebody, my lord. On completion of his 8 hours duty, he comes back, take bath, nice food, and deep slumber. Sleeping and duty is misconduct. Can my learned friend take action for the sleeping or sleeping? Whatever doing beyond duty hours, whatever is being doing beyond the duty hours cannot be within the purview of discipline. Tomorrow, my lord, one person come and he has committed murder. Disciplinary will sit and decide whether murder has been committed or not. And he will punish. But there are certain disciplinary proceedings are.
So why you are saying that he was not
Because,
on
my lord,
duty?
because, my lord,
In the course of his duty, he visited the house.
no,
Why?
he was not on duty.
He was not on duty. Where from we will understand.
That is my case throughout that he was not on duty.
What was your duty hour on that date? On the fateful day, what was your duty hour?
But at that time he was not on duty. Duty was my lord, will say, my lord. On which shift he was.
You have not taken that point in the writ petition.
Yes, my sole argument was that at that point of time, petitioner was not on duty. They did not say that he was not on duty. Remove the hearing of writ petition, landlord never says that he was on duty.
So what did the
He
inquiry authority
is trying to explain on the basis of section 15 of this act that he has to be treated as on duty.
No, that is all right. But what was the finding of the inquiry authority? That he was on duty?
Nothing. Regarding duty, no finding.
Pardon?
Regarding duty, no finding. On duty or not on duty, there is no finding.
So is it your argument that suppose my shift was from 10 to 5? I went to visit that lady at 6 o'clock.
No,
I will be absolved of all my offenses.
not at all, my lord.
Then?
That is what I was saying, my lord. That disciplinary proceedings is conducted and charge of proof on the basis of preponderance of probability. Such type of cases, allegation cannot be proved on the basis of preponderance of probability. That has to be proved beyond all doubt, and evidence will be available. It was proper for them to file a criminal complaint. This was criminal. This is subject
You are
to.
not answering our query.
My
We
lord.
are saying, Mr. Mahapatra, suppose my duty shift was from 10 o'clock in the morning till 5 o'clock in the evening.
My lord.
After my duty, I go to my colleague's friend and I allegedly molest the colleague's wife. Can the entire allegation be shut out on the ground that I was not on duty?
My
How
lord.
was it relevant, sir? It is not a case that you are on holiday. It is a case that you served on that date,
My lord,
but you went to the place maybe.
my lord,
beyond
these
that.
are the judgments of Supreme Court.
Don't show us the factual aspect that he was on duty on which shift and what is your pleading to that effect in the writ petition. In the inquiry authority, what did you say before the inquiry authority?
My lord, regarding place of time of duty, there is nothing. My lord.
Can you say that?
But they also did not say anything.
Maybe.
That he was.
Mr. Mohapatra,
Here they are
you
taking.
are arguing that for the purpose of we appreciate your argument. That then a person will, even after his duty, he can go to sleep also. Will that sleeping hour was also within his duty hour? We understand. But the thing is, allegation against you, you're in discipline force. Allegation against you is that you have molested a lady. Your argument is that has to be established, proved to the hilt in order to be found guilty. That is criminal jurisprudence.
A number of my presenting officer did not say so. There was no evidence. There must be some evidence.
Show us from what you are showing, you show us that what was your duty hour and when did the incident take place. Why this outside of duty come into the picture, I don't understand. Allegation is page, what was the charge against you?
My
Mr.
lord.
Mohammed?
Judge Bay 32.
That is page 31, starts from 31, page 30.
My lord.
Let us read the charge together. That number such and such constable, DPS Durgapur, presently employed on 11th of November 2021 at about 12 hours. You have to show to us that 11th of November was your duty date or not. Were you absent on that date? You were on service. And 12 hours, when was your shift? What is your reply to charge 1?
Only I'll submit, my lord, I was not on duty. The particular duty was
That
never came into
you have to
question.
argue on that point, Mr. Mohapatra.
Page 32 is the representation of his representation. He has not stated, my lord, anything about.
So you
What?
tell us.
Yes,
You
my
tell
lord,
us
so-
which was his shift.
my lord, that I have to, my lord, gather from the official records. I don't have the records today, but so far, my lord, one thing fell from your lordship, antecedent. I'm grateful to your lordship. My lord, he is a habitual person of,
Don't. There we become.
yes. Now, so far,
Do you have
30,
any material to show that on 11th of November he was on duty and his shift was from morning 6 o'clock to evening 6 o'clock?
my lord, that I have to check the record, my lord.
So that is your ground.
I understand, my lord, kindly allow that. So that I
What
can-
was the benefit of doubt given by the presenting officer?
Begum.
Mr. Mohapatra, please
Yeah,
prepare a
pressing matter.
list, prepare a list and the relevant pages. This way it cannot be done.
My lord, this point was not earlier
Mr.
taken.
Mohapatra, Mr. Mohapatra,
My lord,
we are making it hard in part.
my lord, my lord, my lord.
We are keeping it on next Wednesday.
Yes, my lord.
Huh?
My lord,
You complete your argument with a list of dates and finish and give it to us.
my lord,
We will deliver the judgment after it.
my lord. And I will also come with that instructions.
Next Tuesday.
My lord, I will also come with that instructions. Duty hours part. Your lordship, my lord, my lord, বুধবার
learned advocate appearing
Tuesday.
for the appellate. So, is the matter for further consideration on Tuesday as fixed at 2 p.m.
2 p.m. Deeply obliged.
State appellate. Through you prepared the relevant portion of which document you want to see.
Grateful, man.
You make a homework.
My lord.
This is your argument, pages, these are
My lord,
secret. And you take our query.
my lord.
Our query is that on 11th of November, was he within the duty hour it happened, or it was beyond the duty?
Duty, I understand. Though section 15 says that your lordship,
Section 15 that is subject
yes,
to
yes,
correction.
yes. And time is also important,
No,
12
we-
o'clock.
Section 15 will not come into the picture. If you can show
Yes,
that the incident occurred on the within the shifting duty.
my lord, my lord. I understand, I understand. Grateful. Grateful.
Yes, and you also, Mr. Mohapatra, assist us on.
My lord, my lord. 13 তো 13 পেপার বই নেই তো কোনো 13 পেপার বই হয়নি তো
বিশ্বজিৎ মাঝি না,
কলকাতা থেকে কপি দেবো
তো অভ্রনীল কর।
অভ্রনীল
Before my learned senior friend starts, my lord, I shall draw your lordship's kind attention to the order dated 5th January 2021, passed by the Honorable Justice Talukdar and Justice Dasgupta, my lord.
5th January আমিও থাকি পেপার করতে যাই
Yes, Mr. Mukherjee, what do
Yes,
you
my
want?
lord, by this order, my lord, the Honorable Division Bench directed me to produce the records attested by a competent officer. My lord, I have brought those records, my lord. Records pertaining to the selection process.
আচ্ছা, have you given to him?
My lord, I have an extra copy, my lord.
Direction was to consult the records, flag the same, prepare sufficient copies upon
Yes,
attest.
I have it. My lord, here and I am giving. দেখুন আমি submission এর সময়
What was the issue?
my lord, the issue is, my lord, the petitioner, he is a doctor in homeopathy, my lord. He participated in a selection process for the post of Ayush on contract basis. Now, initially, my lord, in the panel, he was, my lord,
43.
against 43. Now, there was a counseling that was postponed. Then, my lord, a re-notice was issued, and my lord, he was directed to appear before the board of counseling, and at that point of time, he found that he is, my lord, against 131. His serial number was 131 instead of 43.
It has gone down,
He was gone down. Now, it was challenged by my learned senior friend
but
Stein.
he was called for counseling.
He was called for counseling.
no
but-
no my lord no
Very well. My lord, the vacancy was 82. Vacancy was 82. Now, what happened, my lord? May I just, very well, my lord. My lord, initially, an agency was entrusted to hold the election, the selection process. Now, at the stage of the first counseling, my lord, the department found, my lord, several discrepancies. The agency was blacklisted, and my lord, the entire panel was recast, my lord, in view of the reasons. My lord, I have, my lord, brought the file notes also. And there are another aspect, my lord. The petitioner applied under OBC. Now,
If he was in the selection process, you found some problem with the agency which was involved to conduct counseling.
the assessment was not properly done.
যে মানে prior to
Prior to-
preparation of
yes,
panel.
yes.
So
At the
your
time
contention is that there were some irregularities in the set process
committed by the agency,
for which his name featured at 40.
43.
And that incorporation does not give him any right,
Right.
because on the basis of such information, you subsequently
Yes.
recast the panel.
Yes, I tell you, lordship, there is one aspect. So far, his case is concerned, my lord, he applied under the category OBC. Now, in the certificate, my lord, produced by him, it was not indicated whether he is an OBC A or OBC B. Now, a clarification was sought for. Now, the department said that if it is not indicated, then he will be considered as a general category candidate. I have brought that notification. Now, on the basis of that, initially he was considered as OBC, but in the certificate, my lord, since there was no category which was indicated, my lord, in terms of that instruction, my lord, he was considered as general category candidate, and that is why, my lord, the serial number, the empanelment number was gone down. These are the reasons.
The writ petition was hard on affidavits.
No, my lord, in the, when the honorable division bench, my lord, taken up this matter for consideration, my lord, I was directed to bring those records, my lord. But if your lordship direct me, my lord, I can file an affidavit within a week, my lord. The entire record attested copies are with me, my lord.
He has to check out. You have just now given it to.
I have just now.
Just now I received.
If your lordship kindly give me, my lord, in a matter like this, my lord, I think an affidavit, although my lord, there was no such direction, my lord, by the honorable division bench. Even before the learned single judge, my lord, I produced the records on that basis. At the motion stage, it was disposed of. As on date, there is no affidavit filed in either before the learned single judge or before the honorable.
On the time, no copy has been served. Pursuant to the order of the learned single judge, no copy has been served on that time.
Why?
This copy on that time not served. আমার কোনো আমার শুধু শুক্রবারটা আছে তাহলে নেক্সট মানডে
Ashok, records reveal that by an order dated 5th January 2021, passed by a coordinate bench of this court, Mr. Mukherjee, learned advocate appearing for the respondents, was directed, quote unquote, to consult the records, actor inverted, flag the same, prepare sufficient copies, obtain attestation of the documents relied upon, unquote. Stop. Pursuant to such direction, Mr. Mukherjee has placed the relevant records for us.
সিরিয়াল নাম্বার
He prays for leave.
নাম্বারটা 13 লিখে
He prays for leave to enclose the said records he prays for leave to file an affidavit in opposition,
the reply
annexing all the said records.
Yes.
But in form, it was Mukherjee, paragraph page 18, it shows OBCB.
Page 18. Yes, OBCB, my lord, he applied. This is his application.
Where is the certificate?
Certificate is at page 20, my lord. Belongs to, my lord, this is to certify that Sri Obronil Kaur, daughter of son of such and such, belongs to Barujibi community, which is recognized as a backward class under government. There is no category, my lord, either.
Categorization came later, na?
No, my lord, the notification that came later, but this instruction is at page 21. This is the clarification.
This is of 2016.
This is of 2016, my lord, and the selection process was held in 18, my lord. Now, this clarification regarding reservation for recruitment concerning persons belonging to OBC categories without OBC A or OBC B.
Where is your decision towards recasting the panel?
My lord, that is, your lordship kindly consider page 10 of this compilation.
There was no other litigation pertaining to this panel.
I do not. I have to check, my lord, from the department, my lord. My lord, this is page 10 is the file note. It's a handwritten note. Your lordship kindly consider this. The second, sorry, my lord, prior to that, my lord, kindly consider the second, the last paragraph.
The posts have been filled up.
My lord, I don't know, my lord. I have.
Any interim order was given?
No,
Why?
the writ petition has been dismissed, my lord. Writ petition was dismissed.
Ashun. Let there be an affidavit then. You will get an opportunity to deal them. All the said. Such prayer is considered and allowed. Let such affidavit in opposition be filed
In 2 weeks, my
2 weeks would be vacation. Right? Vacation.
10 days, my lord. Or my lord, 1 week after vacation, my lord, if possible.
Within a week after the vacation, reply there. If any
Reply
file
1 week,
within a week thereafter, list the matter for further consideration in the daily supplementary list of this court. On 7th December.
Grateful, man. 7th December.
Let the same be kept on record. Produce this, let the same be kept on record. We are retaining.
Yes, yes, my lord.
You have copies?
Yes, I have.
Grateful, my lord.
Great.
Originals are here.
My lord, these are attested.
Attested.
Yes, original are with the in the file.
When you affirm the affidavit, give Xerox copies of those.
Yes, yes.
We are retaining the attested
Yes.
copies.
Great. My position.
22.
I have the instruction to appear on behalf of the respondents in all these matters.
14,
These are analogous matters.
My lord.
14 to 20.
14 to 22 are all analogous matters. Analogous matters means, my lord, they are all the candidates for employment before the railway, Eastern Railway. But their relief they have sought for are all similar. Therefore, a common order was passed. And for the sake of brevity, my lord, the item number 16, my lord, kindly see, Vivekananda Chaurashia, Vivekananda, Union of India versus Vivekananda Chaurashia, item number 16.
Bablu Kumar. 14 is Bablu Kumar.
Kindly take item.
Then kindly take up item number 16.
একটু দাও, 16 ফাইলটা দাও। তারপর Yes, Mr. Were clubbed together. These were separate repetitions, separate
Separate it.
applications arising against the same order.
Same order.
Ah.
Same order.
Now they have used opposition.
Yes, they have used the opposition's.
Item number 16.
Opposition to all the matters.
সবগুলি ফাইল করো। My lord,
Uh,
we have prepared. In our repetition, they have filed affidavit in reply instead of affidavit in opposition. It has to be affidavit in opposition, but they have filed affidavit in reply. So we have no other choice but to file affidavit in reply also. My lord, we have prepared, and my lord, kindly allow me to serve
No, in
whether
all-
all 14 to 22 or one after another.
To another.
No.
Item number
Your
16.
reply is ready. That has been served
Yes,
in
ma'am.
all the, all the.
Yes.
What was the issue?
My lord, issue in this case is this,
The urgency, Mr. Chakraborty?
no, because they have mentioned this matter. They have fixed this matter.
Yes, we have mentioned this matter. Because my lord, the posts are being filled up,
Posts are being
filled up, my lord. But here, what, if I can very briefly, my lord, say, my lord, subject to,
Order was granted. to
no
you.
interim order was granted.
So we fix a date and hear it out after vacation. It will
But,
take some time, Mr. Chakraborty.
But it is a matter, my lord, subject to correction of my lord, senior, my lord, that there has been a direction for reconsideration, against which they have come up before this honorable court. And that too, my lord, when very plain, simply, my lord, if I am permitted, my lord, I have applied in the post by saying that A, B, C, D, E, these categories are my choices. So, my lord, after I, my lord,
Let us hear Mr. Chakraborty.
lord,
My lord,
Are you filling up the post? Are you filling up the
my
post?
lord, in this case, what happened? My lord, first of all, what is the matter is about? The respondents, my lord, who were the petitioner before the learned tribunal, my lord, they filed an original application. Why they have filed that original application? Because they have filed application for against an employment notification. They have filed applications. My lord, there are 5 choices. They can prefer 5 choices. My lord, first there was a written examination. It was all based on merit only. Written examination, those who are successful in the written examination, they have to appear before the physical efficiency test. Is a 1:3 ratio. 1:3 ratio physical efficiency test. After physical efficiency test, there will be original document verification. And original document verification, those who are all successful in the written examination, PET and original document examination, they will appear before the medical examination as per para 7.8 Railway Board Circular being number 121 of 2005. It is pre-empanelment medical examination. My lord, this is very important in our case. In our case, there are 2 things as there. First, pre-empanelment and another is pre-appointment. After pre-empanelment, then appointment process starts. My lord, in our case, there is no allegation against the recruitment process. That is pre-empanelment process. There is no allegation.
Then when did you file the panel?
My lord, I'm telling you, lordship, what happened?
First PET. Second is the document verification.
First written examination, second PET, on the same day, document verification.
Now after that.
After that, on 5th May 2014, there was a medical examination that is for empanelment. After he was successful in the medical examination, he was empaneled. My lord. He was empaneled. The final, because in the year 2015, starting from the year 2015, there was a stay order imposed by the learned tribunal. So nothing was done. But as per the order dated as per the order dated 25th June 2015 of the learned tribunal.
There are 2 medical examinations.
Yes, my lord. One is before empanelment, another is before appointment. Because there was a 3 years gap. And your lordship knows that it is a railway employment. So vision is very much important. Vision is very much important.
So after the medical examination, you prepared the panel.
Yes, madam.
After preparing the panel.
Preparing panel.
There was a gap in completion. As such, you took a decision to conduct a fresh medical exam.
There was no gap of completion, madam. The panel was prepared. Panel was prepared, but due to the, we could not uh, give any effect to the panel because of the stay order.
That
Stay
panel
order,
was-
stay order by the
Very good. That,
tribunal, then my lord, election commission.
no, that panel was prepared after holding the medical test.
After holding the
Medical test.
medical exam, correct?
Now the panel was prepared.
Yes, my lord.
Then what happened?
Panel was prepared. He was impaneled. First, he was impaneled,
Very good.
but panel was not, my lord, not published. Panel was not published. Why panel was not published? Because of the stay order of the learned tribunal.
Very good. Then what did you do?
We could not do anything. We could, because of the stay order, we could not do anything. Thereafter, my lord, by the order of the learned tribunal dated 25th June 2015, the final panel was published on 26th September 2015.
So before preparing this final panel in 2015, you again conducted a medical.
My lord, I'm coming to that. Why I have done so? Because
No,
there
you
is
have
some,
conducted.
yes, my lord, because medical manual allows me to do that. Railway medical manual allows me to do that.
Hmm.
There's a reason I have done so. I will show one after another, your lordship. And nothing has been considered by the learned tribunal.
And then the panel was prepared after medical examination. Panel
After
was
anyway, he was impaneled, and thereafter the order.
taken. In the final panel, was he impaneled?
Yes, my lord.
Then what happened?
That's the thing I'm saying, my lord. My submission is this, my lord. Therefore, the stay order was lifted on 6th October 2016. That's the reason we could not give any effect to that panel. My lord,
Then what was their grievance?
their demand is this, my lord. They appeared in the second medical examination.
Hmm.
They did not challenge it. They did not challenge it because the second admission is,
We understand that.
yes, but they did not challenge it. Their demand is now that they have preferred 5 posts, but five posts in the application.
Hmm.
They have preferred 5 posts. 1, 2, 3, 4, 5. And your lordship knows that the medical examination and all the examinations done in all the courts, there is a common examination. And whoever gets higher marks point, he will secure the highest post. In his case, my lord, he secured, my lord, the gateman. That is the medical category A3. There is a gateman. There is the highest post in his preferred post. He got the highest post 3 years before, in the year 2014. Thereafter, my lord, there is a 3 years gap. The second examination. Because after,
What is their grievance?
their grievance is that when they are unsuccessful, again, they are unsuccessful. In the
How can
second,
they be unsuccessful? You said that in the second panel, after second medical test, all of them were impaneled.
after second medical examination, all of them are not impaneled, my lord. Maybe I could not make you
Your
understand.
first panel was 26 September
Yes.
2015.
Thereafter there was
Let us understand. So prior to that preparation of panel, you held a medical test. 26
Yes.
September 15.
yes, that was in 2014.
That's a very 2000. Thereafter, there was a stay.
Yes.
Nothing could be done. After the stay was lifted, a fresh medical test was conducted.
Lifted thereafter, my lord, the election commissioner imposed moral code of conduct.
Whatever it may be, you
Thereafter,
conducted-
in the year 2017, the recruitment authority, they did not do it. What they have done, they send the panel papers, to the appointing authority, which was the Asansol division. Asansol division they issued him a offer letter, my lord. Offer letter, and thereafter, since there was a 3 years gap, in order to determine whether he is still competent to do the work of gateman, because the vision is very much required, my lord, vision test. So the test was conducted, medical test was conducted. There, second medical test was conducted.
Now what happened? Were they successful?
No, he was not successful there.
Very. At that stage, they moved the tribe.
Yes, my lord. Their demand is this. Their demand is this because in that medical test, he was successful in B1 and below, which is Khalashi. He is saying that why you are not giving me that post? I am entitled to get that post.
Without being successful in the medical exam.
Yes, ma'am. Because there is a railway board guideline, my lord, 90, which says that there is no alternative appointment of medically unfit impanel candidate.
73 page.
Page 73 of the writ petition.
This will take time, Mr. Roy. This cannot be disposed of at this stage.
But if your lordship
Keep
posts,
it on a particular date. You have exchanged your, all materials are on record.
yes, my lord, there. But the matter is, my lord, not that complex, perhaps.
My lord, there are documents have to be shown.
They cannot do ছুটি করে একটা ডেটে দিয়ে দাও।
আমি জ্বর নিয়ে এসেছি।
ও আচ্ছা স্যার, সেটা বলুন স্যার, আমি তাহলে একজন নিয়ে
Let it retain its position on the reopening meeting.
as your lordship pleases. My lord, I'll be filing, my lord, my
Keep it with you, Mr. Roy. Otherwise,
your
we have to pass separate orders.
As your
on
lordship.
those.
As your
It
lordship.
is ready, we understand.
As your lordship.
It will be in the list on the reopening.
As your lordship.
What is your story?
My lord, my lord, when I applied, my lord, there is a, my lord, specific, my lord, point in the pro forma that I can choose posts A, B, C, D, E. A requires A3, B requires C5, C requires B2. This A1, A2, A3, BC, these are, my lord, medical categories, standard of medical category. So, my lord, for post X, standard medical category is A. For Y, it is B. So I choose, my lord, X, Y, Z and ABC. 5 post, my lord, I could choose. After that, my lord, I was successful in X itself, the first one, because I had the equivalent medical criteria.
So for each of the post, separate panels were prepared.
No, separate panel. With single panel, single examination, everything single. I was given the, in the pro forma, I could choose X, Y, Z, ABC. If I am not successful in X, then I'll be considered in Y.
Very good.
If not
you
Z,
emerged to be successful in which one?
I was successful at the very first time in X itself.
Very
I
good.
had the highest, my lord, medical category, the medical qualification. And after that, my lord, they once again decide that I will be once again taking the medical examination when the stay order was lifted. So, my lord, they once again took the medical examination. My lord, objected to that, be that I will not take this point right now. Thereafter, my lord, what happens? I was not successful in equivalent to XS. My medical category, I was successful, let us say in Y. So, my lord, my specific case before the tribunal, since it is a provisional panel,
Why you were not included in the second?
this is what my case before your lordship, before the learned tribunal.
So you appeared in the second medical examination
My
and
lord, similar, one medical examination is taken. And in that one medical examination, my standard is determined. It may be A, it may be B,
so
it may be
was
C.
determined and found previously
I was A.
you are X. Now, when it was held 3 years later, you were no longer eligible for X, but you were eligible for some other category.
Grateful. My lord. That is exactly my case is. And this is why I was not given appointment, went before the learned tribunal. Learned tribunal said, you should revisit his case because he is eligible with respect to Y, Z, A, B, C, etc.
But that panel has lost its force.
But it doesn't, my lord. In
2 years.
since 27, after that, my lord, since 2019, my lord, it was there in force. During this meantime, my lord, the order was passed. My lord, went before the learned tribunal, my lord, and I am also, my lord, equipped. My lord, I have the document, my lord, to show before your lordship. There has been. I'm sorry, my lord. This is why, my lord, the learned tribunal only said that let them revisit with respect to my other selection that I made. They have, my lord, come up with a different case altogether before Honorable High Court.
My lord, before empanelment, that their choices could be taken. See, if he was unsuccessful in grade A,
You have not
then
been
we-
asked to,
then
Mr.
see,
Chakraborty,
the
you have
after panel is prepared, my lord.
not been asked to give appointment. You have
Yes.
been asked to re-examine. What is the wrong in that direction? Court has not said, disallowed your arguments and said, it is not that your arguments have not been accepted. In the conspectus of facts, court thought it fit that you must give it a second thought. You consider it, you dismiss, finished, you take all your grounds. But why do you want to injunct them at this stage? Tribunal has not directed you to give direct appointment.
Because it is not the, my lord, kindly appreciate this thing, that it is not the within the jurisdiction of the recruitment authority. Their direction is on the recruitment authority. How the recruitment authority will give this, will comply. Because it is just, they have no jurisdiction to appoint. They have no jurisdiction to appoint. I have taken the specific stand. Recruitment authorities, their role was over when the panel was published. Thereafter, they have no role. Recruitment authority have no role, my lord. Appointing authority has role. They did not make the appointing authority party in this proceeding, because the direction should be on the appointing authority. They have all the panel papers and everything are with them only.
We will direct the appointing authority to re-examine.
Because they did not make them party. So the direction of the tribunal was on the recruitment authority.
So the recruitment authority is the appointing authority.
No, my lord. Recruitment authority, here the appointing
So
authority.
your grievance is that the direction should not be upon the
Recruitment authority, which has
Then
no
who is the
jurisdiction.
authority? Tell us.
My lord, this is my first point. My second point is this. When the panel is prepared as per the as per the preference mentioned in the application, my lord. Panel is prepared. His name is empaneled. Thereafter, he has no right to say to give him in the next post after he is unsuccessful in the medical examination. Second, he has no right. I have the case laws, my lord. Supreme Court.
Mr. Chakraborty, the process was stalled by orders of court. These points which you are taking, this situation has occurred. Since the
Yes, my lord,
entire
I
process
understand
was
that.
delayed.
It is due to
Now,
the
it is tribunal has never directed that you give him appointment. If your grievance is that the appropriate authority has not been directed, you take instruction. We will modify the order. But what is the wrong in re-examining it? Upon re-examination, if this is the ground you take, that having applied under A category to which X category medical examination is required, you have been unsuccessful in that question of re-empanelment does not occur. So that is within your liberty. You can reject the case also. What is the wrong? We will modify the order. If your grievance is that recruitment board or the recruitment authority is not no longer in session of the matter, then the records are with you. And tribunal has directed. I don't think, Mr. Chakraborty, you please take instruction on that.
Yes.
Then the issue can be resolved.
Will I come back after vacation, my lord? It will take some time.
Yes. Take it up.
Grateful.
Reopening it.
In the supplementary list.
বলে দিন না কে পয়েন্টিং আছে ঠিক আছে
To place this before the department, my lord.
Heard Mr. Chakraborty, learned advocate appearing for the petitioners, and Mr. Rai, learned advocate appearing for all the respondents.
My lord. My lord, different respondents in different WP numbers.
Appearing for the respondents. Let us club together all the matters. This can be hard analogous. No? In same matter, you have filed opposition. Please one by one hand over this opposition and
My lord, opposition to be kota diyesho.
Position, my lord, there has been a mistake on our part as well. Or it would have been, my lord, affidavit in opposition, I
no,
said.
but have you prepared in
No.
all the matters?
In 9 matters, they have filed opposition in 6 matters, which they said reply. 6 matters.
Which are those matters?
6 matters bole din. Bole din.
Take up, take up.
6 matters.
Item 14, you have the affidavits.
Yes, ma'am.
Give one by one. এটা
আপনি
item
বলুন,
14.
আপনি বলুন। কোনটা?
At the line, বলেছো তো? Let the affidavits exchanged by the parties, comma, as filed, comma, be kept on
কোনটা
record.
দিলেন?
List
First
the
item.
matter or
First
further
item. এই প্রথমটা।
consideration under the
14.
same heading in the daily supplementary list.
The second.
Daily supplementary list of this court on 5th December বলে দিচ্ছি। তাড়াতাড়ি আবার কম্বাইন লিস্ট বের হয় যদি তোমার ডিসেম্বর 16 আছে 5th December 5th December আচ্ছা this is in item 14 you have given the affidavits
Yes, ma'am.
এই নাও এটা সাথে
Item 14. Bablu 14. My lord, this is item number 14.
14 প্লিজ ওটা একটু দেখে নাও না অপোজিশনটা রিপ্লাই দিতে বাধা নয় ডিসপ্লেস হয়ে যাবে
Item 14.
14 এবার where is your 15 document
Madam. Mithilesh Kumar.
নিয়েছো
আপনি
16 17
17, my lord, I did not use this.
in which other matter you have
My lord, 17, 19 and 22, my lord, I did not.
17 19 and 22 you did not fight naturally you have not
No, I did not. And আরেকটা কি
in the
file করুন?
meantime you fight ওই এটাতে 17 19 আর 20 তে করো আর
It is not
Mr.
fine.
চক্রবর্তী learned advocate appearing for
19, 22.
such and such Mr. Roy stop This the matter for further consideration. The daily supplement on such a 5th December. Stop. The parties would be at liberty to exchange their affidavits in the meantime. এটা 17, 19, 20 তে এই অর্ডারটা call 18, give the copy.
সোমনাথ ভট্টাচার্য
অর্ডার কবেতে হবে তুমি ওটা
সোমনাথ
এটা
ভট্টাচার্য।
আবার তোমার মিস
কপিটা হচ্ছে। ওটার কপিটা হচ্ছে
19টা সেপারেট ওটাতে আর অপোজিশন
My lord,
20
28
20.
and 21.
21 টা
21, it is not ready for us. 21 is not ready for us now.
তাহলে হার্ড করে দাও। Let the affidavit in opposition filed by the respondent
Ready for.
be kept on record. Stop. Petitioners would be at liberty to use a reply to the same within a week after the vacation. Is the matter for further consideration on 5th December. That's separate. Astari করেছি।
Lordship, may permit to mention one matter, Lordship. Given notice is an original side matter. The matter of court number 12, when Honorable Justice Chakraborty was there, an order, interim order was there. It was up to, it is for a period of 12 weeks.
So what it is extension with my lord.
Yes, my lord.
Oh, is it?
12 weeks, Lordship. So,
To mention before the regular way.
Lordship, it will, within the vacation, it will come.
No,
Within the vacation, Lordship, because it's the 9th August.
my lord would be sitting on.
In the list, it is showing 9 to 19th.
No, that is there, but at the top you see, our determination is up to 11. To
to
wait
11.
on 12th.
He benched,
12th, Honorable Justice Velumoni may sit with my lord.
I'm the,
If it doesn't happen, then you come back.
I'm diplomat.
But that is May. I have said May.
No, right, sir.
Please keep a watch. If that bench is not available, come back.
Lord, I'm appearing for the appellant.
And I am appearing for the
Respondent number
petitioner
25. My lord, I request your lordship, my lord, kindly con- my lord, the kindly my lord, your lordships kindly take up the memorandum of appeal and or your lordships will get the order
Dr.
dated.
Kundu, Dr. Kundu. And Mr. Mitra is for the commission, school system. Who is for the state? Yes.
Now your lordships kindly consider the order under appeal dated 5th October 2023. Your lordships will get it at page, my lord, in the memorandum of appeal. Lord, your losses kindly go through it. I'm not reading it out. You do that, your losses kindly.
Who is the appellant before us?
I'm respond number 25th, 25th, Dr. My lord, Sunanda Goenka, principal of the college.
Yes.
Now, my lord, one thing I must, before placing my
Who is
appeal,
the petitioner? Who is the petitioner?
petitioner is one of the students of the 9th semester of the college, law college. Now, my lord, before,
What was challenged in the writ petition?
my lord, I will take your losses. His challenge was first in regard to the appointment and recommendation of 25, respondent 25, 26 and 27. And the other one by way of writ of mandamus, and the other part of the writ petition, your losses, regarding police inaction or certain criminal activities. But I will take your losses to that. But before taking up this matter, your losses kindly take up these two orders. In regard to the same order, another appeal was moved on behalf of my learned friend, learned junior, regarding bar council. My lord, against the very first paragraph. I must bring it to your losses notice. Then I will take up to your losses on the merit of the appeal. My lord, I only just request your losses, my lord, kindly consider particularly paragraph 6 of the order.
So you are the principal. You are challenging the order of removal.
Order of removal. I tell your losses, my lord.
Any
Kindly,
other direction you are challenging in the order?
my lord, or making it hard in part. I objected to that. My lord, may I proceed, my lord? I will not take much time. Your losses, kindly look at page 41. This is the notice I was served through mail in the night of 4th, my lord, October 2023. Just see the, my lord, language of this notice. My lord, the last two lines. His lordship, after hearing the urgency involved in the above referred matter, was pleased to fix the matter for hearing on 5th. My lord, this writ petition was affirmed itself on 4th. Now I take your losses to the prayer portion of the writ petition. If your losses kindly come up, your losses, there are two parts of the prayer. So many prayers your losses will find page 86. Lord, Lord, first prayer B, your losses to ensure that no person without adequate qualification as laid down by UGC during their time of appointment is allowed to continue in the service. Little vague, my lord, but it will be clear, but probably from the subsequent prayers. Your losses, kindly the next page. Issued direction upon the respondent numbers 2, 3, and 7 to revoke the recommendation of the appointment issued for the post of principal of Dr. Shwenda Goenka. My lord, the appellant before your losses. D, to recover the salaries paid to the Dr. Manik Bhattacharya, my lord, erstwhile principal, who was retired from the college in 2014, if I am not wrong. Then Dr. Sunanda Goenka and Achina Kundu and late Nilangshu Bhattacharya since April 2000. E, to stop post-retirement benefits of Dr. Manik Bhattacharya, Dr. Nilangshu Bhattacharya, and to take further steps to recover the post-retirement benefit. EF.
Just one second. Yes.
Then paragraph prayer F. Declaring the service of Dr. Manik Bhattacharya, Dr. Sunanda Goenka, Dr. Rachina Kundu, Dr. Nilangshu Bhattacharya had been obtained on fraud and hence liable to be set aside since inception. G, declaration declaring salaries paid from the state exchequer to all these persons is illegal and should be recovered. Then your lordships, a writ in the nature to issue directing the respondents to ensure that no antisocial non-student elements, specifically such and such by name, to enter the college premises at any point of time, including the events of the college. Then I, my lord, to transmit the records, receipt of certiorari, the records case forming the basis of non-action inaction of the concerned respondent authority not taking steps with regard to illegalities committed in the respondent college, all that. Then your lordships, again J, directing criminal investigation by an agency beyond the control of the government into the illegal appointment of these 4 professors, your lordships. Then rule 9 side. Well, kind of a look prayer L to rest the nature of interim order prayed for. An order do issue directing the commissioner of police to produce a report with regard to the actions in regard to the certain complaint of 2023 August 9. An order do issue directing the commissioner of police to produce a report regarding the fate of the criminal investigation. Then N, directing to produce a report on affidavit regarding the illegality of appointment in terms of the qualification and teaching experience. O, issue directing respondents, my lord, to produce a report on the affidavit regarding.
No, what was the, you are recommended teacher?
Recommended principal since 2015.
Where is your commission recommendation? There is no commission recommendation.
I think commission recommended. College Service Commission.
So, College Service.
College Service Commission. My lord, I tell you, Lord, I was a.
Why she has been removed? What is the allegation against her?
My lord, according to, as I find, according to Act, I did not have the NET or SLATE qualification.
In
1998. My lord, when the college was a private affiliated college. Now, my lord, I tell you,
the time of
at
your
the time,
appointment.
So
subsequently, you
subsequent, my lord, in 2000, 2001, the college came under the, my lord, grant and aid scheme, pay package scheme, in other words, called. Now, thereafter, in 2015, through College Service Commission, I have been recommended for appointment as principal. Now,
So you do not have the net slate qualification?
Net slate qualification. My lord, I tell you, lordships, since your lordship asking me, when I was appointed in the private college, my lord, there was no regulation of UGC requiring net slate.
98.
1998.
You were appointed in which college?
Jogesh Chandra College as a lecturer. At that point of time, the regulation was of 2019 and 1991 that didn't require net slate. Net slate came thereafter. And now the net slate is also not compulsory. If I'm not wrong, if someone have PhD, it doesn't require. Now the point is that your lordships, with this prayer, if your lordships permit me, I can take your lordships to the affirmance.
Do you have your commission recommendation?
Do you have a commission recommendation? Right now, I do not have. No,
What is the date of that recommendation?
Recommendation date?
2nd July 2015.
2nd July 2015, appointed on the recommendation. 26 December 20. And I stand corrected.
So recommendation was in December 2015. He joined in July 26.
And then obviously
Then he
after the
joined,
recommendation.
She joined.
After
Thereafter, she was continuing.
Now, my lord, the point I am raising, your lordships, my lord, on the very first point, my lord, what was the urgency involved that this matter pertains to the determination of the Honorable Mr. Justice Chandra?
That Mr. Sannal.
My lord, I tell you, lords, I tell you, lordships, there must be some pleading. What's the urgency in this? With this prayer, my lord? Because why I'm telling your lordships, on the very first day, I am removed.
Which direction you are challenging? Tell us that.
Well, the direction I am challenging your lordships. First, your lordships kindly consider page 2 of the order, internal page 2, the second paragraph.
We have read that.
Well, is it, my lord, I'm putting a question to myself. My lord, is it the procedure to be followed?
We have read that. So
Then your lordship, paragraph 6, I am questioning your lordships. Removal. My lord, there is no prayer for quo warranto. How can there be removal? But without hearing me, I asked, prayed for time. That's my prayer, your losses. Your losses will find it because that was considered to be misconduct on the part of my junior.
No, very good. We are wanting to know the entirety of the order is not being challenged. You are challenging some directions issued against your
And the
client.
final removal, order of removal.
You are one of the respondents.
One of
the other persons who have been removed.
No, I'm not on that. I'm not. Other person means another professor.
Whatever it may be.
So for Manik
They are
Bhattacharya
not
is no
before
longer
us.
there.
They are not before.
No,
us.
not
We are
only.
to your grievance.
Only.
So
And
your grievance is removed.
and the other point, my lord, the learned judge make it heard in part. That's against the my lord, direction of the list of the Honorable Chief Justice. It cannot be. This is because this is the determination of Justice Chandra. Justice Chandra has my lord, again my lord, sitting my lord since 9. This matter was moved in 6th.
That is the discretion of the judge.
My lord, I tell you, lordships, my lord, I join little.
Urgent
My
determination.
lord, I tell you, lordships, urgent determination I can take up 6th. Can it be made hard in part if I take an exception? I took an exception to your lordships.
That is the discretion of a judge.
My lord,
who going into the case have passed various directions.
My lord, I tell you,
Now,
lordships.
whether it will be kept as part heard or it will be not kept as part heard, that cannot be decided by us. It is the exercise of discretion. If you are challenging the legality of such direction, I think then you have to take other steps, not before a coordinate bench.
My lord, the order passed,
This is
your
an
lordship.
administrative allotment of.
No, this is a coordinate bench, your lordship. My lord, before the appeal
No,
bench.
this direction for assignment of the urgent matters, it is an administrative direction of the master of the roster.
That's true.
That has been done. Now this has been considered as part heard because it appears my lord has called for some reports and everything. That is why part heard. You tell us what you are agreed by your removal.
Remove.
Now what has happened to the special officer who was appointed? He went there. Yes, Mr. Orman. Did you go?
We asserted the senior most teacher, that was Mr. Masood Haq. With the help of Mr. Haq, we sealed the office of the principal. On the 6th morning, we had intimated the principal to be present. On 9th morning, my particular 9th morning, we had arrived. We had taken. I placed the report, which I had filed before my lord the.
So you were asked to.
And the charge has been taken by Masood Haq. The signatures have been changed, and the person concerned is now Masood Haq, the teacher in charge. As per the order dated 9th October, which modifies this particular.
Where is that order? 9th October, there was another order.
That's why I'm so, my lord, at the time of mentioning, my lord, I told you, losses. It has been made part heard and there are 2-3 orders passed.
You have not challenged this. Huh?
No, this is the order of 9.
You have not challenged.
Not yet, not yet. My lord, I challenge the very first order. If my removal order goes, everything should go.
9th order kindly says, I informed the honorable single judge about the appeal. Kindly, they chose not to appear before the honorable single judge yesterday. And before goes into this order, only one indulgence, as a special officer, as I was appearing for the state, the honorable single judge was pleased to appoint me as a special officer. As a special officer, I took the opportunity to have a talk with the president of the governing body, because the records of the state was speaking something very starkly dangerous, which Mr. Hon'ble will assist. He is leading me in the matters of the state is concerned. And whatever we could ascertain, I shall place it in the report. We'll see there are certain things, which needs to be considered by the division bench before any order is placed.
Malad, I take to this I tell you losses.
Just.
একটু পেছনে শোন।
Now your losses will find entire thing after the order of 6th, which is now before your losses. My submissions are very short. Now I'm questioning the propriety and correctness of the order of 6th October. 5th October, I'm sorry, Malad. If the 5th October order goes, Malad, all subsequent orders should go. If my removal at the very threshold, Malad, I tell your losses, before your losses or before the learned single judge, there was nothing except the writ petition and conversation through mobile phone of the learned advocate of the petitioner. If I'm not wrong, that mobile phone belongs to learned advocate for the petitioner, mouth speaker was made on, and learned single judge heard it and then did it. But that was not correct submissions recorded also, because our case is that when I was appointed in the private college, there was no need of net on Slack. Now the point, my lord, can it be done without calling for an affidavit? It is so urgent, my lord. My lord, your lordship must confine, my lord, rather should confine what was before your lordships, not today, whatever will be producing by them. This was not before the learned single judge.
Which was not before.
Except, my lord, what my learned friend I heard, Mr. Banerjee would be producing certain things. My lord, I don't find. My lord,
Which was,
On 5th and affidavit was on 6th. Matter was again taken up on 6th of October. There was a direction upon State and College Service Commission to file affidavits on 9th when they were not appearing. The Honorable Single Judge first deferred the matter till 4 o'clock because the matter was supposed to appear before another division bench at 2 p.m. Thereafter, my lord, at 4 p.m. it was again taken up, 4:15 or so. My lord asked for the affidavits, we have filed an affidavit.
my lord, kindly see the chain of events. Is it so hurriedly? So hurriedly, my lord.
so why didn't you appear and tell?
But why? Because we are, my lord, yesterday, 3 benches refused to hear it out. Mr. Bhattacharya's request, my lord, Mr. Bhattacharya specifically made a request that since the matter has not been taken up before any division bench and they are pursuing the matter, we get assigned, my lord, the matter was urgent thereafter. Now, what's the wrong in it, my lord? Since we have prepared, right or wrong, since we are not. My lord, I am there.
But Mr. Shanna, this subsequent order is not in appeal before us.
All right, your lordships. Now, if your lordships say that 5th October order removing me is correct, my lord, I can't stand before your lordships. My point is, on the day of motion, can one be removed without sufficient records before the court? I should not be heard, my lord, in regard to the petition. Well, that shows, my lord, this was made urgent.
This the determination to be.
ওটা না।
Yes, by the state as well as by the College Service Commission.
Mr. Shanna, you finish your argument.
Lord, I request your losses to kindly,
Had
because
they been there in court, they would have got copies.
that's different. My lord, kindly consider this notification.
And may I just,
Shanna, this argument is necessary.
Necessary, my lord.
You are an impleaded respondent in the writ petition.
That's true.
There had been a.
My lord, I tell you losses, my lord, I must be clear to your losses.
No,
My lord,
you cannot direct that cancel the parted and you shall not hear. This is something which you are seeking is.
No, my lord, the first point, your losses.
Not
My lord, I tell you losses. The first point, there was no urgency involved, even pleaded in the writ petition. My lord, kindly.
Very good. That we will consider in the context of your order of removal. If we hold in your favor that removal is bad, suppose we hold in your favor removal is bad, what consequential?
My lord, may I tell one thing, losses? I appear before a particular court. Now, very first day, my learned advocate paid for adjournment.
That was.
My lord, kindly, my lord, see why I am not, my lord. Rather, I do not want to go before that court. The way before the court proceedings are being run. The proceedings, my lord, how do I go before that court? Now, the first day I was removed over telephonic conversation. which is not recognized a procedure laid down by law, neither civil procedure code, not our writ rules. Then how do I dare to appear before that court and make my submissions?
That is not a ground for non-appearance.
No, I appeared. I tell you, loss is further continuance. Further continuance with the after change of determination.
So you ought to have appeared and
I appeared every day.
ninth you did. not
Ninth, I tell you, losses. Ninth,
That
I
has been recorded by the court.
That's your losses. Lanet Court has recorded everything, your losses. Recorded, that my junior refused to talk to over phone and take instructions.
That-
Very first order, your losses. Can you have a look
So
at this?
that order has been done away with.
Milord, on the
That's
sixth,
what-
Milord,
I tell you, losses. Doing away with on appeal is one thing. And what I suffered before the learned single judge is another thing, your losses. Then I have to go on each and every appeal. That's we are trying level best to get it hard before the honorable division bench. 3 honorable judges refused to accept the assignment. So in the meantime, this order passed. This is the resultant effect of this.
Yes, show us what was the report placed.
Before that, may I just indicate one thing? Milord, on the 6th, when Milord, the advocate concerned, Milord, Mr. Mukherjee moved the appeal, Milord, upon obtaining leave. Milord, I also, in solidarity, Milord, supported his cause, Milord, and appeared and said that this portion of the order should go. Now, Milord, on the 6th, the matter was made returnable by the 5th order. On the 6th, Mr. Mukherjee appeared to inform the honorable single judge. I also appeared, Milord, and informed his lordship on the 6th that, Milord, from the 5th order an appeal has been carried. The honorable division bench intends that the matter is fixed on 9th, that is yesterday, division bench of Justice Sen. The matter is fixed on 9th. Please do not do anything till 9th. The honorable single judge accepted. Mr. Mukherjee was also there representing the respondent number 25 on the 6th, that is Friday. Thereafter, Milord, on the 9th, the matter appeared before his lordship, the division bench. The division bench proposed to release it. Thereafter, Milord, it traveled to 3 other division benches. The matter could not. But the fact remains, Milord, everyone was aware that on the 9th, the matter is fixed at 3 p.m., 4 p.m. Milord, they could have entered appearance and informed. On the contrary, Milord, out of my own volition, Milord, so as to preempt everything, Milord, I informed the division bench. They did not choose to appear. Milord, it is incorrect.
Before the division bench.
Before the honorable single judge, 6th they appeared. 6th, Mr. Mukherjee appeared, if I am not mistaken.
Yes, we have heard that. That is clear.
Milord, so therefore, Milord, they are not being heard. They are not being, Milord, preempt. Nothing is correct in my respectful submission.
Now, on 9th, this order upon the special officer, that we want to know that what was this report of the special officer.
No,
we'll go to that first.
Milord,
now, what, Mr. Bhattacharya, you are a student of the college.
My lord.
What is your legal right to challenge the appointment of a principal of your college?
Milord,
does it, on the contrary, do not reflect your audacity? That you can every day come to High Court and file a petition and obtain removal order.
Milord, here, Milord, if your lordship sees, Milord, at the glaring facts.
So, you have substantive practice. Tell us what is your legal right in the writ.
Milord, I have a legal right to be taught by teachers who are qualified in law. Qualified, Milord, as per UGC regulations.
So according to you, the recommendation was bad.
Yes. Yes.
Why did you sleep for these 10 years?
Milord,
2015 was the recommendation.
2015 was the recommendation. I was not a student in 2015. I am a student, Milord, after that. And Milord, what has happened, I'll tell you, lordship. Milord, despite the writ petitioner in the entire appeal papers, your lordship will not get a single sentence that she is qualified. I go out of court. The honorable single judge has protected her. Milord, the honorable single judge intends that if she files an affidavit disclosing her qualification and everything, she will be reinstated.
But what we are wanting to know is, there is a valid order of recommendation.
Valid order of recommendation by the college service. Yes.
It has to be tested, Mr. Bhattacharya.
Undoubtedly so. But Milord, prima facie, Milord, with all humility, Milord, 1998 she was appointed.
What was your writ petition foundation is a police complaint which you made.
No, Milord, that is another aspect of the matter. That is another aspect of the matter. Milord, my writ petition also concerns My writ petition, my lord,
Which semester?
my lord, 9th semester.
Show your result. Show your result in the exams. Give your examination results to
আছে?
us.
এখনই আছে? Result আনতে পারবে?
Huh?
I should
Ninth
show. I should
semester
show,
law
yes.
student.
Yes, I should
Ninth
show.
semester law student. What was your rank in the open invitation, open test which was filed?
ডাকো, ডাকো।
How much percentage did you secure in your HS examination?
I'll find.
That you ought to have found out before drafting the writ petition, Mr. Bhattacharya.
এই যে। This is not.
No, no, Mr.
He is in 9th semester, so he must have been admitted in the year we are in
My lord,
18.
2018 admission.
2018.
Registration is of 17.
17. At that time, I think there was no common examination.
Yes.
There was a common exam.
Common exam, entrance test.
Yes.
Yes. Entrance test started me a long time back.
So what was your
But she secured. কিসে 70? My lord, average till date is 70%.
what was your rank in the test? In the common
Entrance
exam,
test.
huh?
যোগেশে চান্স পেয়েছে মানে ভালোই। Must be somewhere, my lord, in the, because Jogesh is one of the 4 colleges, my lord, the government colleges. University of Calcutta, my lord, that is Hazra, Jogesh, Surendranath, and South Calcutta. 4 colleges, my lord, they feature in the first ranks.
You are in the governing
was
body.
119.
You are in the student
119. My rank was 119
you are in the
out of 5,000. 119 out of 5,000.
no, you were in the students union,
No.
or you are a governing body member.
There in Jogesh Chaudhary, there is no students. আছে নাকি?
Government, there was the direction of the government that there shall be no elections to be given any further that has been going on all over the state for a long time.
Oh, I see. No, it has not been constituted as yet. Governing body, this election students union,
there's-
Election in the state of West Bengal itself, the government has stopped.
government has.
But as of now.
Mr. Bhattacharya, what do you say about this removal order?
My lord, my humble submission is, my lord, in the stay application, first of all, my first submission is, my lord, in the stay application, my learned friend has sought to justify her appointment by saying that she is an LLM with 58% marks.
No, we are not on that.
No,
We are,
My lord, the issue is net slate. My lord, at the time of our
net slate determination is not, if it is not there with the principal, is she not entitled to place records that whether at all there was through requirement?
my lord, she has.
No, is she not, is she
My lord, may I answer to your lordship? My lord, this college, she has been appointed in 1998 in a private college. Jogesh Chaudhary Trust was done. My lord, humbly. My lord, they came under the government pay packet sometime in 2000-2001, which, my lord, government pay packet obliged them to have UGC recognized qualifications. UGC recognized qualification at the material point of time was, my lord, either a PhD, which she did not have, or a net slate with 55% marks. My lord, apparently, certain 5%, 6%, my lord, at the material point of time came under the UGC pay packet. 2 of them carried writ petitions to your lordship's court, including appeals. A division bench of your lordship court in 2016, presided over by a honorable honorable judge, my lord, who has since demitted office, decided the matter, relegated the entire issue to the government. The government came to categorical findings, despite one of them, my lord,
Mr. Bhattacharya, we are not on that.
No,
We are
okay.
only wanting to know.
she was called.
Never appeared.
She never appeared.
She filed a review.
My lord, may I say this? Apropos the honorable division bench's order, an inquiry was conducted. The inquiry report apparently is today disclosed by the state. And, my lord, it also appears that the state, through the DPI, has been, my lord, every other day writing to the administrator of the college, who is also an officer of the state, who has kept it up his sleeves not to conduct the inquiry as envisaged in the inquiry report. Goenka, Mrs. Goenka, Dr. Goenka, my lord, The appellant, despite not having full knowledge of the report, as a principal of the college, she kept it with her, not disclosed it to the governing body, not disclosed it to anyone. The DPI writes to the administrator of the college, who was at the helm of the affairs then. The administrator of the college, also has to answer your lordship, as to why.
Exactly.
Now,
We will get
these are
the
facts.
Mr. Bhattacharya, that is your standpoint. That is a bad person. Say, take us. She has violated the government direction. Is she not entitled to a small-
To the inquiry committee.
She was
never
called,
appeared.
this is one thing. She was called before the inquiry committee. She was served a show cause. She chose not to, these facts are not before your lordship. She has been served with a show cause by the administrator, I am told. Let the administrator answer. I think the state's officer was the administrator then.
Since they do not appear, I don't know inquiry committee পাঠাচ্ছি কিন্তু এগুলোতে যায়নি এই জাজমেন্টের রিভিউ
What is your answer to this issue that on the first day when the writ petition was moved, as the advocate could not submit on her behalf, the person, the honorable court had a telephonic conversation, as it appears from the record. And the question was put, do you have net slate? Have you covered net slate? She must have said that, no, I have not covered. On that basis, the removal order was passed. But the court said that there is a possibility that this punishment can be withdrawn if you give a reply satisfying your stand.
Let her.
Exactly. But why the removal will remain?
Removal.
I am expressing a possibility that you can give me a letter. If your letter sufficiently justifies your non-availability of those qualifications, then I will reinstate you. But before you come to the finding, you
remove two things. First is, this is an inherent lack of qualification of the concerned person. She was inherently lacking in qualification to be appointed as an assistant professor in the year 1998. When she came under the pay package, she lacked inherently lacked in qualification insofar as appointment, because the relevant qualification was a net slate. Relevant, even if whatever be the nature of college. Today your lordship is 98. There were 5 private colleges. Today there are 5,000 private colleges across the country. AICTE affiliated. Every private college today has to conform to UGC qualifications. Apart from that, what I respectfully say, she had a chance to inform the honorable court on the 6th itself. On the 6th itself, by way of an affidavit, that this is my qualification, kindly reinstate me. This is my qualification. She'll never be able to show that her initial appointment from 1998 and onwards was as per UGC qualification. তোমার কাছে পড়েছে আমার শিক্ষক তো তুমি চলে আসবে আপনি কোন কলেজে পড়েছেন? আমাদের কলেজে? না না, আমি আমাদের কলেজ মানে আমি বলছি ডিপার্টমেন্ট অফ ল, ইউনিভার্সিটি অফ ক্যালকাটা, মানে হার্ডিং। তারপরে বিদেশে। না আপনি বুঝবেন না, ওই আপনার জন্য নয়। হ্যাঁ
is your stand?
Your lordship will also look into the judgment and order made by your lordship's court, which is reported in 2017 to CLT 22. That is, the division bench, on the same issue. I have a copy. On the same issue. দুটোই। Your lordship may take this.
No, give one copy, we shall share.
My lord, 2017 2, my lord, this is slightly marked. Your lordship may take it, my lord. It is, my lord, kindly excuse my impertinence, my lord. It's marked.
Unmarked copy.
No, an unmarked copy is there. My lord, Justice Chakraborty, kindly, my lord, I'll give it to your lordship. 17 2 CLT, my lord. The Honorable Division Bench gave them an opportunity. My lord, after dismissing the appeals of Bulbul Sarkar Rai and Shampa Bhanjo, my lord, whom we chose, my lord, there, my lord, kindly see what has been done.
Mr. Bhattacharya, did you show this judgment to the Honorable
Yes,
Single Judge?
Yes, yes.
Huh? You showed this
Yes.
document?
By the petitioners themselves.
My lord,
The
Find any
respondents.
reflection
My lord,
anywhere in the order.
Respondents they had shown,
Mr.
and I had said that
Bhattacharya,
it
we
is
are
reported.
putting you a simple question.
my lord.
Whether a person has a right to reply to the allegations leveled or not. Yes or no? Tell us.
That's keeping from the chance.
You will be.
My lord, as an officer of court,
as
my
an
lord, yes.
officer, yes. No,
As an officer of court, yes.
that is very fair on your part. Now,
You know, no person can be condemned unheard. There cannot be two views to that.
it is
But
a-
at the same time,
no, we understand your anxiety, but at the same time, if the honorable court from the order it appears that these are the things I find, your advocate has not spoken for you, you have said you don't have the qualification, you are removed. But if you can satisfy me, I will reinstate. This is the direction. So the honorable court was of the opinion that there may be a possibility that she can be reinstated upon considering her objections to the allegation.
my lord, now, my lord, I put it
Now,
this way.
if that is not done, you are removing him.
My lord, now I put it this way. My lord, I put this question entirely to myself. Now my lords are in session over the matter. In the application for stay, my lord, what is the averment made by the by the respondent number 25 appellant that she is qualified? My lord, we don't have a case. We don't have a case. She'll be reinstated tomorrow.
No, whether she was qualified as per the requirements in
My lord,
2015.
yes.
This has to be checked.
My
No?
lord, I am answering your lordship. My lord, it is not there.
Let the court take the trouble. Why you are troubling us?
My lord, kindly sees what the averment is. Kindly sees what the averment is. Kindly see what she has said in the appeal. My lord, please come to the stay application. My lord, paragraph 6, page 17. Kindly sees paragraph 6, page 17.
Yes.
My lord, kindly sees what is her averment. My lord, what is the statement? Thereafter, my lord, kindly sees. Yes, paragraph 10.
এবার কথা হচ্ছে ওটা জাস্টিফাই করতে হবে যে তুমি এটা ছাড়াও তুমি কত কিভাবে দেবে।
My lord, my lord, every technical objections have been taken in the appeal,
আমাদের
which he or she has a right to take.
তুমি একটা নোট ফোকাস করবে।
And apart from saying the basic thing that she is qualified, all possible technical objections taken, apart from saying that yes, this is my certificate, this is the qualification earmarked in 1998, I was not obliged to take that qualification. That statement is missing. My lord, kindly visualize. My lord, even in 1998, this is the qualification, UGC qualification. My lord, this is the qualification of UGC in 1998.
Yes.
Now, please see.
So who will consider it? Appeal court will consider.
My lord, if the appeals,
We will go into this inquiry.
my lord, kindly pardons me in saying this. My lord, if the petitioner feels that she has been condemned unheard and she has everything under the sun with her, then at least, my lord, there should be a bare whisper in the appeal papers that yes, this is my certificate, these are my qualifications, this is the qualification in 1998, and therefore I fulfilled the qualification. The qualification in 1998 for an assistant professor, my lord, is this.
So she will go to the, if she cannot satisfy, she will be removed.
My lord, today,
You being a student,
yes,
you are wanting that the principal should go first principal to be gone. I am a student union member, I want the principal to go.
again,
Your audacity.
my lord, again,
This is your audacity.
my lord, kindly.
When were you born? 2018. And your principal was appointed prior to that in 2015.
Lord,
And
Lord,
you make a writ petition a subject matter of
my humble
this complaint.
submission is, even my lord, there are, documents from the College Service Commission's report and the state's report that the state's report that, despite, I showed your lordship this order made by your lordship's court, in 2016.
Yes,
This
Mr.
envisaged an inquiry. Kindly
Yes,
see the
Mr.
order.
Bandyopadhyay.
And it contemplated a notice to her. She refused to, participate in the inquiry. Findings returned. The TPI writes to her to do something. Nothing is done. Nothing is done. She merely keeps it up her sleeves. Today, these documents are coming, because the Honorable Single Judge intended that a special officer be appointed.
Yes.
I am producing. I am producing a copy of the affidavit.
Stop kept.
I am
No, first tell us, no. Tell us what had happened.
Lord, initially, Lord, there was an order of 23rd of December 2016. Lord, that is in MAT 458 of 2016.
The order handed over.
The order which was handed over.
That was,
Reported judge.
this is relating to the same college.
Yes, yes. Same.
Same college, same teachers. Lord, there two other teachers, Lord, came praying for equal status as three other teachers. That was rejected, saying that you do not have the qualification, you will not get it. But my lord, a direction was given for the state to make a committee of 5 persons, make a committee. Ultimately, which committee had 5 persons, my lord, 2 judicial members and 3 administrative members. Now, my lord, this committee, my lord, took up the issue with regard to the qualification of 4 teachers. One of Dr. Manik Bhattacharya, one of Dr. Sunanda Goenka, one of Dr. Achina Kundu, and one of Dr. Nilangshu Bhattacharya. Now, my lord, in the meantime, Dr. Manik Bhattacharya had retired, and Dr. Nilangshu Bhattacharya had expired. Therefore, the issue remained with regard to Dr. Manik Bhattacharya, Dr. Goenka, and Dr. Kundu. Now, this committee returned a finding in 2019 saying that Dr. Manik Bhattacharya had requisite qualification, but the others did not have requisite qualification. The final report is with me. Now, on the basis of that report, dated, my lord, 5th of July 2019, which committee members were, my lord, the Secretary Judicial Department, the Secretary in charge Law Department, Director of Public Instructions, Special Secretary Department of Higher Education, and Deputy Secretary Department of Finance. My lord, the members being the Secretary Judicial Department and Secretary in charge Law Department were the judicial members, my lord, WBJS. Now, my lord, this finding, my lord, culminated into an order passed by the Special Secretary in terms of the order in the order of the Honorable Division Bench.
That the committee's resolution to be placed before the special secretary.
Yes. So the Special Secretary passes an order on 18th of March 2020.
2020.
Yes. But I am only reading 2 paragraphs of it, my lord, in place of handing it over, my lord. That whereas the said committee has submitted a report to the Chief Secretary on 5th July 2019 with the observation that the principle of equality before law was violated to some extent at the point of time in giving effect to the circular dated 11th of January 2001 issued by the Higher Education Department while extending the benefit of the said circular to Dr. Sunanda Goenka, Dr. Achina Kundu, Dr. Nilangshu Bhattacharya to the extent that these teachers did not have UGC prescribed qualifications. However, in regard to Dr. Manik Bhattacharya, the committee left the matter to the Higher Education Department to examine the veracity of the experience certificate of Dr. Bhattacharya for becoming the principal of the said college by the appropriate authority. Then skipping over 2 paragraphs, my lord, it says in the last paragraph that in this connection, the governor is pleased to direct that the Director of Public Instruction shall take appropriate actions, including disciplinary proceeding against Dr. Goenka and Dr. Kundu, in terms of the findings of the inquiry committee as constituted by the Chief Secretary, as per the extant rules at an early date with intimation to this department. It is not out of context to mention that Dr. Nilangshu Bhattacharya has died in the meantime. Now, my lord, this order, that is of 18th of March 2020, was forwarded by the DPI, Director of Public Instructions, my lord, on 15th of June 2020. At that time, there was no president of the governing body. My lord, there is another chain of events with regard to Dr. Manik Bhattacharya, which I am not placing because he is not an appellant before your lordship. On 15th of June, it was sent to the administrator of the college, saying that an action taken report may be submitted to the undersigned within 7 days of receipt of this letter. Now, my lord, this is followed by another letter of the DPI of 9th of December 2022, now to the president of the governing body who was appointed in the meantime. And followed by another letter dated 27th of December 2022. And lastly, a letter dated 11th of January 2023.
So the recommendation was that you take steps against this person.
Against these persons. And my lord, these 4
That was in
letters
2020. That was
starting
in
from 2020 up to January 2023. Up to January 2023.
So any proceeding was initiated?
My lord, from the department, just file ta rakhar moto. My lord, the administrator at that point of time wrote back to the DPI by sending an action taken report on 2nd of July 2020.
Yes.
My lord, an action taken report was sent on 2nd of July 2020, which referred to, and my lord, perhaps enclosed also, my lord, because no enclosure is marked, one show cause notice dated 2nd of July 2020 was sent to Dr. Goenka
So by the
the then administrator.
But fact remains that no proceeding has been initiated.
But at fact, what remains, what I find from the departmental record is that after that show cause, there is neither any reply nor any further steps after the president came in place of the administrator. And my lord, all these letters up to January 2023, but I have gone through the file, my lord. there is no reply from the side of the college back to the department that what action has been taken. I can show from these letters, repeatedly what has been said is that, please tell us what action has been taken in terms of that March 2020. Now, what appears from the report which was filed by the special officer yesterday, after some proceeding in the college, it appears that the other members of the governing body was never aware of these letters being sent to the college. I will not come to a conclusion. I'll leave it to your lordships to come to the conclusion. The appellant here was the secretary of the governing body. These letters, when I was college of this student, I was member of the governing body being a student representative, which is not there anymore. What I have learned from that experience of 1 year is that all the letters are placed in the governing body through the secretary of the governing body, not by the president of the governing body. So this is what is appearing from the file, and this is the pertinent letter, which was placed by the state on 5th of October when this order was passed.
All these documents must be with the appellant.
This was forwarded. Or show cause has been given to them. I don't find it in the appeal petition which has been served upon.
In 2020.
This show cause is of 2020, July 2020.
The administrator.
By the
Then the president came.
Then the president.
Then she became secretary.
She was always the secretary. Ex officio. The principal is ex officio secretary.
No.
Of the governing.
The administrator was there.
Then also, she was the secretary. She was the DDOs. This is the letter which was placed by the state on 5th of October. And thereafter, there was a direction to file this file it in the form of an affidavit on 6th of October, which we filed on 9th of October, that is yesterday. We had placed it on 5th of October. May I place one copy, if your lordship kindly permit,
Now,
page 4, bottom paragraph onwards.
This is the report of 9th of October.
This is
special officer report.
No. This is state's report, state's affidavit, enclosing the documents which was placed before the Honorable Single Judge on 5th of October.
On that day, affidavit was ready.
On 5th of October, these documents which are part of the affidavit were placed from the file as instructions.
On 5th?
On 5th October.
When the order was passed?
On the order was passed.
5th was the order of removal?
Yes. On 5th of October. On 6th of October, the direction was given that whatever loose documents have been handed over, put it in the form of an affidavit. This was placed before the court on 9th of October, that is yesterday. This affidavit, in the form of affidavit, it was filed on yesterday.
Then Mr. Bandyopadhyay, how the commission issued the recommendation in favor of this person?
Commission has also filed an affidavit. In paragraph 19, if I am not wrong, they say that for the post of principal, there is no requirement of net or slate. For the post of principal. So perhaps the commission at that point of time did not go into the question of net or slate. But what I have understood from the file and the recommendation of the committee, which was constituted by the chief secretary, is that the question is not really of being a principal. Question is of whether there is an eligible teacher or not, which is probably the foundation for being a principal. Because one has to have an experience as a teacher, then the question of becoming a principal comes, along with PhD, etc., etc. The other requirements. And my lord, this page 4, which your lordship will find has been communicated in page 6 of that affidavit, because page 6 at the bottom shows enclosed as above. Page 6 will show that 18th March is 18th March is enclosed with the first letter to the administrator dated 15th of June. This, in my understanding, is not under challenge for the last 3.5 years. This has not been challenged.
5th of June, that is from the DPI.
Yes, this kindly sees enclosure as above, which encloses 18th June.
Oh, with a request to initiate appropriate.
Yes, this already enclosed the finding that these teachers did not have UGC prescribed qualification. This finding of the committee, incorporated in the order of the special secretary, has not been challenged for the last 3.5 years. As per my knowledge, the appellants will correct me if I'm wrong. And the show cause has not been replied to. That also the appellants will correct me if I'm wrong. The show cause has not been disclosed in the appeal. The appellants will correct me if I'm wrong.
Referred to in the
That did not disclose, not referred. This is the position, my lord. And my lord, the entire report of the 5-member committee is also there if your lordship.
Where is that?
My lord, it is not part of that affidavit. My lord, this was also placed yesterday. On the first day, my lord, copies were not there, my lord. I could not place it. Now the step ফাইলে আছে তো গভর্নমেন্টের ফাইলটা তো well after quoting the relevant paragraphs from the division bench order, my lord, presided over my lord Justice Rakesh Tiwari, as his lordship then was, your lordship will be pleased to kindly come. My lord, division bench's order, your lordships will kindly be pleased to, my lord, come to the relevant portion. That is page 6. My lord, some portions are marked, my lord. I'm sorry, my lord. Kindly, my lord. Page 6, second paragraph, as regards. My lord, in 2001, the two requirements when the college came under UGC, my lord, was drawing of UGC pay scale and having UGC prescribed qualification. These were the two requirements. The finding in short of this is with regard to the teachers, except Dr. Manik Bhattacharya, is that they drew UGC scale of pay, but they did not have UGC prescribed qualification. Now, kindly take page 6, second paragraph, as regards. As regards having UGC prescribed qualification by Sri Manik Bhattacharya, Principal, Sri Nilangshu Bhattacharya, Lecturer, since deceased, Srimati Achina Kundu, Lecturer, and Srimati Sunanda Goenka, Lecturer, it is apparent from the write-up of the Higher Education Department and DPI that only Sri Manik Bhattacharya had got the required qualification as per UGC regulation of 1991, and other three opposite parties were working as whole-time teachers at the material point of time did not have required qualification as per UGC regulations. Point may be arisen as to whether this inquiry committee may enter into the issue as to whether the aforesaid four opposite parties have had UGC prescribed qualification in 2001 because of the fact that by the said circular only teachers or principals drawing UGC scale of pay prior to the date were covered. Then kindly skips over, but then next paragraph, from the documents filed. From the documents filed by the petitioners and also from the write-up of the Higher Education Department and DPI, there is no room to doubt that Sri Nilangshu Bhattacharya, Srimati Achina Kundu, Srimati Sunanda Goenka, all working whole-time lecturers and drawing UGC scale of pay were lacking UGC prescribed qualification at the material point of time as because they did not qualify net and slate at that time. As regards Sri Bhattacharya, who was appointed as principal of the college in 1998, the Higher Education Department by DPI jointly have submitted that Sri Bhattacharya had UGC prescribed qualification to be appointed as principal of the college. Then kindly skips over the issue with regard to Dr. Bhattacharya is at page 7, which the Honorable Single Judge has said he will deal with tomorrow when the matter comes up. Here, this paragraph with here at page 7. Here, the petitioner's contention is that how Sri Bhattacharya, working as full-time teacher in Vijaygarh Vidyapeeth, acquired his experience as teaching law subjects for more than 16 years, as because Sri Bhattacharya resigned from his post as school teacher in the forenoon of 1st of August 1998, and he joined the law college on the very date. It is the submission of the higher education and DPI of the to the said contention that at the material point of time there was no hard and fast rule that a candidate must have experience as a full-time teacher. So and so, Dr. Bhattacharya, this only we, since he is not before the court at that point of time, kindly, take page 8, second last paragraph. In view of the aforesaid. In view of the aforesaid discussion in light of the documents placed before the committee, this committee unanimously conclude that the principle of equality before law was violated to some extent at that point of time in giving effect to a circular dated so and so, while extending the benefit of the said circular to the aforesaid opposite party. Unhesitantly, it can be concluded that despite non-fulfillment of the two conditions together as mentioned in the circular of 11th of January 2001, namely having UGC prescribed qualification and drawing UGC scale of pay, Sri Bhattacharya, Srimati Kundu and Srimati Goenka, all whole-time lecturers, were favored by extending benefit of the circular dated 11th of January 2001, and as regards Sri Bhattacharya, principal of the Instant College, in favor of whom also the benefit of circular was extended, the issue relating to experience need scrutiny or examination or investigation by competent authority for coming to the conclusion on the said point, whether despite non-fulfillment of two conditions as mentioned in circular dated 2001, Sri Bhattacharya was extended the benefit of the circular. The report of the inquiry committee from approval so and so, then it was forwarded.
So where is that portion that net slate qualification was not there?
That is at page page 6, last paragraph. From the documents, first 5 lines.
So this is at the time of entry.
At the time of
did
entry.
not have the
Qualification.
So that was at that time UGC prescribed qualification.
I have the qualification.
But she was given the benefit of that 11. She was brought within the scope of that circular of pay structure, granting it.
Yes. UGC, yes.
But instead of that, as per UGC, that was a requirement.
One was 55% in masters and one is net and slate. As far as this appellant is concerned, net and slate was not there, 55% marks was there. As far as the other teacher who has been removed by the order of the Honorable Single Judge, 55% marks itself was not there. But it's no point going into that aspect at all, because that is not subject matter of
Now
this appeal.
Before this committee, did they get an opportunity?
Dr. Goenka did not appear,
Did not appear.
citing and review which was pending before this court at her instance. That review, that review has not been heard out till date. I do not know whether any steps has been taken with regard to the review or not.
Review of Justice Tiwari's order.
Review of Justice Tiwari's order, pending till date. There was an appeal preferred before the Honorable Supreme Court. It was rejected.
In the appeal court, the issue there was parity of the teachers.
2 teachers wanted the same benefit as these 4.
I see. Who were those? They were those Bulbul Sarkar Roy.
And Shampa Bhand.
We represented them.
Bulbul Sarkar Roy.
We wanted to say that we stand on the same footing as that of them, and therefore we should be also conferred the same.
Writ court dismissed your prayer.
Writ court dismissed, appeal court dismissed, not entertained.
Not entertained with the direction that
The direction to go into this.
An appeal was preferred before the Honorable Supreme Court, by Dr. Goenka. That was rejected. Probably, if my memory stands correctly, liberty was given to prefer a review. Review has been filed, but it remains pending. There is some reference of that.
The writ petition is the last page.
So she refused to appear before the inquiry committee. Where do we get that? Is there any?
The Supreme Court's order is at page 98 of the writ papers.
Mr. Bhattacharya, you have
Sorry.
finished.
Yes, my lord, kindly takes page 2, second paragraph
Of the
of the my lord,
inquiry report.
that committee's report, my lord. Final report,
Second.
page 2, second.
Uh-huh. Had appeared along with that.
My lord, 1, 2, 3, 4, 5, 6, 7 lines from the bottom, soon thereafter. Soon thereafter, the inquiry committee met on 21st December 2017 and resolved to request Dr. Bhattacharya, Dr. Goenka, Dr. Kundu, Dr. Bhattacharya to appear before the inquiry committee on 27 January 2018, along with all their academic certificates, order relating to appointment, regularization, etc. But none of them felt any need to appear before the committee for submission of any papers in support of their individual cases and also for making any oral submission. It is stated clearly that till date, no competent court of law has passed any order restraining the proceedings of the inquiry committee in any manner.
Also sleeping.
My lord, I cannot better the facts or the timeline, my lord, from the bar, my lord. My lord, the dates are before your lordship, my lord.
Now, anyway, now you have already, you have been, you have handed over charge to the teacher in charge. Now, what is the, this principal's room is still under lock and key?
But there is some reason perhaps, my lord, because my lord, today what I have not, I have not prepared the report for today's, my lord, as yet, because my lord, the appeal was fixed at 2 and my lord, now it appears that the single bench has fixed the matter at 4, my lord. Today, my lord, we tried to ascertain many things, my lord, out of which one was that whether the files of the service academic files, which shows the academic records of Dr. Kundu and Dr. Goenka, is available in any part of the college. We could not. So, my lord, either it is in the principal's office, my lord, or it has been taken. So, there is some point to that effect, my lord, which we do not know. And, my lord, so far as the reports are concerned, my lord, let us check with them.
It is Gotokala report.
Gotokala.
My lord, the appellants do not have a copy of this report before the Honorable Single Judge directed it to be circulated among the appearing parties.
My lord, then there was not a direction in the order, my lord. So
that is what we heard in court, that circulate the report to the appearing parties.
Lord, will kindly take up page
But
31.
I do not have a copy of that.
Yes, because they were not
Lord,
a appearing
has a copy. It's on the
party
court.
yesterday.
My lord,
They were not an appearing
my lord,
party
will
yesterday.
kindly take up page 31. Lord, page 31 is the proceedings, my lord, of the 9th of October. My lord, will kindly take up page 32 once. Lord, page 32, my lord, I am reading out the serial number 2. Lord, the special officer showed, my lord, these are the geos which Mr. Bandopadhyay has already referred to in the affidavit of the DPI, that these were the documents which was constantly sent to the college so that Dr. Goenka and Dr. Ochina Kundu is proceeded against. My lord, the question which I had put to the teaching and non-teaching members of the governing body of the college, my lord, according to them, they neither have any knowledge of the said documents, nor the said documents were ever placed before the governing body.
Where you are reading?
My lord, page 32, serial 2. My lord, we'll see, my lord, after the numbers are, my lord, 11 January 2023, my lord, the date. My lord, to the the special officer showed such and such to the teaching and non-teaching members of the governing body of the college. According to them, they neither have any knowledge of the state documents nor the state documents were ever placed before the governing body.
Now, what are these GOs?
My lord, these are the GOs which Mr. Bandyopadhyay referred to in the affidavit, my lord, of the DPI.
But Mr. Bandyopadhyay has given only one 15th of June 2020. This was the communication of DPI.
But in that affidavit, there is a.
Can you take page 6, 7,
No, there are.
6, 7, 8,
6, 7 is to the president. 8 is also to the president. Now,
in the meantime, the president came.
who is the president?
Member of Parliament,
Mr. Malarai, Mrs. Malarai.
And the principal continues to be the ex officio.
Yes,
sec-
always.
Now she is secretary. Now the administrator is not there. So she is the regular secretary as the principal.
Lord, since January 2020.
Only show cause which was issued when the state's officer was the administrator. Only show cause which was issued was when the government officer was the administrator. Thereafter, nothing happened. As per our file.
Milord, to that effect, Milord, I had a discussion with Mrs. Mala Roy by virtue of being the special officer, Milord. Mrs. Mala Roy's contention is she was never aware of this.
Not even these letters.
No. This is the contention of Mrs. Mala Roy.
Where is it? Where have you stated that oral whatever you had,
Milord,
you have
Milord, I
stated?
had told her, Milord, that you have to file an affidavit to that effect, Milord, because I do not want to take that upon me. Milord, Mrs. Malaroy has sent me a letter, Milord, I can show that, Milord, which says that I am authorized to represent her so that the interest of the college is safe for now, Milord, because the governing body has not met to appoint any other advocate so far as present situation is concerned, Milord. If,
What is the situation in college now?
Milord, the academics are going on,
Peaceful.
Milord.
Now this person who has appointed as the teacher in charge.
From 6th, the college was fine. 9th, the college was fine. Even 10th, Milord, today, I will be showing, Milord, the proceedings of today, Milord, where it is specifically recorded. Kindly allow me to- Milord, this is today's proceedings, Milord. Milord, Milord will kindly take up the second page, Milord, which is serial number 6.
System is same for
Yes.
So, Milord, the academics is not hampered at all. It is absolutely peaceful situation, Milord. And Milord, the report which I was placing, Milord, serial 2, the governing body members do not have any knowledge so far as any of the communication the government was sending, Milord, because it is generally sent to the college office. College office is held by the principal, Milord, who is the appellant before, Milord. So the documents remains whatever the documents are sent is remain with the principal. And Milord will kindly. Yes. And Milord, there is another third point of that report, Milord. There was a criminal case which Honorable Justice Gangopadhyay had taken note of. This criminal case was with regard to, there was a 156 clause 3 filed by one of the student members of the governing body in 2018. The 156 clause 3 said that Dr. Achina Kundu, Sunanda Goenka, Manik Bhattacharya and everybody do not have qualifications and they have obtained services illegally. Milord, in that particular case also, Milord, it was never placed before the governing body. However, Milord, if Milord calls for the reports, Milord will see that there are replies from the college to the police authorities.
Mr. Mitro, you have anything to say?
And Milord, one more point, Milord, which appears from the writ petition, which may not be documented, Milord. Mr. Subiresh Bhattacharya, there is the allegation that Mr. Subiresh Bhattacharya was the governing body member. At the relevant point of time, Dr. Sunanda Goenka was appointed as the principal. There is some allegation that is Dr. Subiresh.
Well, one thing I say before I start making my submission, my lord. It is a good thing that I am not a law college student now. I am very glad, my lord, that I have passed out long back. At that point of time, we never had to face this. If the students, my lord, in a college face this kind of situation, I do not know, my lord, what will be the future of the students in this state. I'm very sorry to have to say this. This is absolutely appalling. My lord, apparently, my lord, as I was hearing Mr. Bandyopadhyay, things have taken place of which, my lord, nobody is aware, excepting, my lord, the government. I don't know what steps government had taken for the purpose of, my lord, removal of these persons, or, my lord, taking steps against these persons. But, my lord, today, the education system is in shambles. Well, I'm making this submission before your lordship, not as a counsel for the commission, but, my lord, as a member of the public. And I'm sure, my lord, everybody in this court will agree with me. What is the state of affairs? And the order is passed by the court removing persons. Maybe they are guilty, but even a guilty person, even a person who has, my lord, committed crime, he has got the right to defend himself. Without, my lord, hearing the orders are being passed, I don't know. I don't know, my lord, what I shall say. But anyway, I come back to, my lord, so far as the College Service Commission is concerned. My lord, I am to mention these things. First is this Bosho. First is this to be, so far as respondent 25 is concerned, my lord, I have been directed by the court to, my lord, give answers to 2 questions. And that is the 6th of October. 2 questions were posed. And, my lord, I have been directed to file a report on those 2 issues. The first issue is, what is the qualification required for appointment and getting salary under the pay package system of the government of West Bengal?
There before the writ court.
Oh, yes, yes. Well, of course, I was personally not there. But, my lord, the commission was there before. Yes, my lord, junior appeared before.
So those 2 points have been answered by you.
No, my lord, we have answered this in the form of an affidavit. As the court had directed me to file a report in the form of an affidavit, we have done it.
I see.
So, my lord, the 2 questions are, what is the qualification required? What is the qualification required for appointment and getting salary under the pay package system of the government of West Bengal? That is the first question. And second is, whether there is any difference in qualification of a teacher of a college when he is under pay package system and when he is appointed by the College Service Commission, that is under the qualification norms laid down by the University Grants Commission. These are the 2 questions which are posed. Well, your lordship has got the affidavit. Kindly, my lord, come to straight away to paragraph 14 of this report. My lord, kindly come to paragraph 14. I'm just going to very shortly make my submission. Well, the respondent number 25, who is the appellant before your lordship, joined the college, this college, Jogesh Chandra College, as lecturer in 1998, when this college was a private college. Then, my lord, on 8th February 2020, the University of Calcutta granted permanent affiliation to the said college, and the said college was recognized by the UGC in December 2000. And subsequently, pursuant to the government order dated 11th January 2001, the service of the respondent 25 has been regularized, as it has been mentioned in the writ petition in paragraph 7. So, my lord, kindly see these things. My lord, the respondent number 25, the appellant, joined the college as a lecturer when the college was a private college. At that point of time, net slet was not there. It was not born. So there was no question of, my lord, applying this principle of net slet. On 8 February 2000, the University of Calcutta granted recognition to this college and it was affiliated. Then the UGC in December 2000, my lord, recognized this college, and, my lord, on 11th January 2001, this college was recognized, my lord, the service of the respondent number 25 was recognized by the government. So, my lord, this was the state of affairs. Then what happened was this, my lord.
Just a short interruption, Mr.
Yes.
Mishra, that this regularization decision was on the basis of the 11 January circular.
Yes, my lord.
At that time, there was no net slate.
No, my lord. Your lordship will kindly see next when UGC regulations came into existence, then the question of, my lord, what are the qualifications required, that came into existence.
So on 11th of January 21, it was a UGC recognized college.
Yes.
So at that juncture,
But at that point of time, she was already there, engaged. She was appointed in the college. She was working as a teacher. So, my lord, this was the position at that point of time. I'm giving your lordship the facts exactly what as it happened. Now, my lord, so far as UGC is concerned, your lordship will kindly take, my lord, this is one of the questions which has been put. What was the educational qualification required? And, my lord, kindly take, my lord, this affidavit where it has been said out. Kindly come to paragraph 10. I state that in the notification issued by the UGC, my lord, paragraph 10.
Yes.
This is very important. Issued by the UGC being number so and so, which is UGC regulation on minimum qualifications for appointment of teachers and other academic staff in the universities and colleges, and measures for the maintenance of standard in higher education, 2010. The qualification for the selection of the post of principal has been prescribed in the following manner. Kindly see, a master's degree with at least 55% marks or an equivalent grade in a point scale wherever grading system is followed by a recognized university. Then 2, a PhD degree in concerned /allied relevant disciplines in the institution concerned with evidence of published work and research guidance. Then 3, associate professor or professor with a total experience of 15 years of teaching, research, administration in universities, colleges, and the institutions of higher education. And then, my lord, a minimum score as stipulated in the academic performance indicator API. Now, my lord, at that, your lordship kindly sees that once one gets this PhD degree and a degree, master's degree, 55% or more, then, my lord, net slate was not necessary. It was not required.
But she was not having PhD.
Yes. She is in 2008. She was, well, this is, well, so far as we are concerned, well, this commission is concerned, commission only recommended on the basis of what? On the basis of UGC guideline and, my lord, guideline which has been provided by the state government. Strictly, my lord, they were applied in respect of this. And, my lord, it was found when she was appointed the principal that she had all the qualifications. She got 58.8% in the masters, and she, my lord, was a PhD degree holder. And in 2013, when she was appointed, she had completed 15 years of, my lord, 15 years period as a teacher. So, my lord, she qualified and she was selected. My lord, she was selected. The selection is not by me. Selection, I am to recommend only that she is a fit candidate. The appointment is made by, my lord, by, my lord, the authority is concerned. College makes the appointment, and that was done. Therefore, my lord, so far as my duty is concerned, that was completed. Because, my lord, I found, my lord, my client found at the time when she was appointed that she had all the requisite qualifications to be appointed as principal. And that's why she was appointed. And that happened in 2015. Each of the dates is important. So from 2015, my lord, the counseling, my lord, she was not allowed the counseling because, my lord, she was not an associate professor. So counseling was, my lord, she was prevented from having the counseling. She moved the court. My lord, that particular application was moved. Just a minute. The order was passed on 25th March 2015. Kindly come to page 57. Mr. Dipankar Datta was pleased to pass this order, permitting counseling. This is, my lord, dated 25th March 2015. And this date, my lord, kindly see the 3 writ petitions involved, etc. All petitioners are teachers employed in different colleges. They had applied pursuant to an advertisement issued by the West Bengal College Service Commission for selection and consequent appointment on the posts of principals in colleges where vacancies exist. It is not in doubt that the 3 petitioners have been impaneled as follows: Niranjan Mondal, Anita Chattopadhyay Gupta, and Sunanda Goenka Bhattacharya. She is, my lord, the respondent number 25 and appellant before your lordship. The asterisk marks put against the names of the petitioners is explained at the foot of the panel as follows. Quote, counseling of the applicant is subjected to the production of government memo in favor of associate professor designation, which they did not have. Since the petitioners have not yet been able to produce the relevant orders issued by the government designating them as associate professors, and the counseling is scheduled to be held today, they have presented the respective writ petitions seeking orders on the state government to issue orders designating them as associate professors. As and by way of an interim order, it has been prayed that the commission be directed to allow the petitioners to participate in the counseling scheduled to be held on 25th March 2015 without insisting upon production of the relevant orders, and issued to the government designating them as associate professors. One of the essential qualifications that an aspirant for the post of principal must possess is that she or he ought to hold the rank of associate professor in university, college, institution, higher education. It is evident from the chart produced by Ms. Bhattacharya, learned advocate for the state, in one of the writ petitions, that all the petitioners are entitled to be designated as associate professors. However, it is submitted by her that such designation could not be effected because of certain anomalies which were required to be rectified and may take time. The anomalies referred to by Ms. Bhattacharya are referable to the fact that the petitioners were designated as readers without putting in 5 years service as lecturers senior grade. However, the petitioners having agreed to be designated as readers upon completion of 5 years service as lecturers senior grade, they would be entitled to be designated as readers and associate professors in terms of the following schedule. Then, my lord, after the schedule has been set out, it would appear from the above that it is a formal recognition of the promotion of the petitioner of the post of associate professor that is awaited, that they are entitled to be so designated. They are entitled to be so designated is not in dispute. In the above view of the matter, I am of the prima facie opinion that the petitioners cannot be made to suffer only because they have not been designated as associate professors by the government till date. In such circumstances, the petitioners having set up a strong prima facie case for the grant of interim order, I direct that the petitioners shall be entitled to participate in the counseling scheduled to be held today. However, selection, recommendation, and appointment, if any, made in favor of the petitioner shall abide by the result of the respective writ petition. This writ petition was disposed of. Finally, my lord, and this was confirmed. This, your lordship will be pleased to find. This was done, my lord, by the learned judge taking up the writ petition afterwards. So, my lord, this is the state of affairs insofar as this petitioner is concerned. Whatever has transpired thereafter, my lord, it is not to my knowledge. I do not know whether the commission knew about all this or not. But, my lord, this is the way this particular lady had been appointed, selected, recommended, and, my lord, appointed.
But Mr. Mitra, the inquiry committee, the special inquiry committee set up,
These are not on record.
these are not on record.
These are not on record.
Says that she did not participate.
No, my lord, I do not know. I am not appearing for her. I am sure my learned friend will answer this. But what I am submitting before your lordship is this, that these are all there. These have to come before the court. But now, my lord, I am speaking as an officer of the court, as a counsel who has put in practice for so many years. I have not come across a single order of this court. I say that with the conviction that I have got in my possession. I have not seen not a single order in which a person has been condemned unheard. I have never seen, my lord, I say so say so without, with my lord, without any fear of contradiction, with as much conviction as I have got, that over the telephone, a person is asked whether you have got net slat, and thereafter an order is passed. My lord, I am aggrieved because I am a part of this institution. This order ought not to have been passed.
But Mr. Mithro, all the backlog stories which are not on record, which has just
Let them come on record. Thereafter, the order will be passed. After giving a hearing to the parties concerned, all the parties should be there. I am now not speaking, my lord, as my lord counsel for the commission.
But what,
Now I am speaking, my lord, on my own behalf.
Mr. Mithro, she has been removed. As a consequential to that, the special officer has taken charge and done.
Who has taken charge? The students have taken charge of this college. Who is running this college now? Special officer will be running the college. I have never heard such a thing in my life. No, just a minute. The principal had been driven out. Padlock has been put on the door of it. However, my lord, whatever, my lord, has been done by the principal, she must be given a hearing before you drive him out, before you say that your service is terminated.
Right. So if at this stage, my lord, if at this stage this court interferes with the order of removal,
yes,
then what will be her status? Then the appointment of the special officer also has to be go. This
Of course, it will have to be stayed. My lord, if in my respectful submission, if a special officer has been appointed, a person has been made to cease as the principal of the college, ex parte, without giving her a hearing, then my lord, that particular order has to be stayed, so that, my lord, the status quo ante may be restored, matter may be heard properly in a court of law as it is heard. All parties must be heard, given an opportunity of hearing, and thereafter the necessary order should be passed. That is the only way, my lord, justice can be done. Justice, my lord, must be not only must be done, must be seen to have been done. What will, my lord, what impression, my lord, I will get, my learned friends, but the common man on the street will get, that the High Court passes order without hearing the parties? The person concerned may have committed a crime, a heinous crime for that matter. But even then, he has got the right to be heard. He cannot be, my lord, condemned without being heard. And this is what has happened. This should not have happened. What is to be happened? My respectful submission is order should be stayed. My lord, situation ante should be restored. The padlock should be removed. The administration of the college should be handed over to the principal and to the teachers who are there. The governing body is there. Let the governing body take steps against the person concerned. If he has committed a crime, let the governing body take steps. Let them come to court. The court passes the order after hearing the party. That is how it should be done. And by 2015 onwards, she has been the principal of the college. And today we are in 2023. So such urgency has, my lord, come about that the court had to pass an order on the basis of a telephone conversation. Well, I respectfully submit to your lordship, I am anxious that, my lord, justice should be restored. My lord, I am anguished because justice has not been done. I therefore respectfully submit to your lordship that, so far as the commission is concerned, commission is quite clear in its mind. Recommendation has been made in terms of the, my lord, in terms of the UGC guidelines. State government has recognized this particular institution, recognized this particular person. Let it be de-recognized on the basis of whatever comes back. Mr. Bandyopadhyay has put forward a lot of things. The learned special officer has put forward a lot of things. They should come before the court. Well, it has not come in before the trial court when, my lord, this order was passed, impugned order was passed. Were they produced before the learned judge at that time? Nothing is, my lord, is on record. No, my lord, nothing has been recorded.
Not on 5th, when the order was passed.
No, on the documents. No, which are part of my affidavit.
No, those documents are not referred to in the court's order.
No, those documents are placed. My learned senior was not there. Those documents were placed, that is why the direction came to file it in the form of affidavit.
Right, so
We were,
the court did not get the
the court should have waited.
opportunity to go through everything.
It is being submitted that it was not before that, only, I'm not on these contentions. Those documents where I had placed it from the file, I have placed it. Page 4 onwards. My affidavit.
order নেই কিছু
Order I do not find any.
না কোর্টে এগুলো কিছু দেখো না
Which the
But in fact, there is a paragraph which refers to my name and what on this Mr. Bandopadhyay, etc.
My submission is this, my lord, that I think that for the ends of justice, my lord, this order should be set aside. Matter should be sent back to the trial court. After, my lord, giving a hearing to the parties, whether on affidavit or otherwise, when, my lord, the documents will be placed before the court, then, my lord, the matter can be heard and the order can be passed. Then, my lord, nobody will have a grievance against the order. Today, kindly see, my lord, the grievance is not on the merit, but on the procedure. Well, today, it seems, well, the grievance of the appellant is, well, on the not the merit, but on the.
We appreciate your submissions, Mr. But today, as a consequence of that order, now water has flown. He has taken over charges, the drawing and.
Who has taken over charges?
Special officer. Now the teacher in charge has been placed there. Suppose today, the interim order which Mr. Hon'ble would be seeking, and as a senior member of the bar, what you are submitting. If the removal order is stayed, then the principal, he gets back the status of principal.
Right.
If he gets back the status of principal, then nobody else can be the drawing and disbursing officer. Then the appointment of the special officer also has to go.
My lord, I submit to your lordship, my lord, that today, what is going to happen? It is as if the writ petition is being heard de novo. That is exactly what is going to happen. And my lord, a thing which has continued since 2015, openly, broadly, in the presence of everybody. My lord, heavens won't fall if, my lord, it continues for 7 more days. I mean, I don't see any damage being done, any harm being done to anybody. The student, my lord, who has come up before your lordship, his grievance is that I am being taught by a person who is not qualified. Well, a doctorate,
Allegedly.
Allegedly. Well, whether that is correct or not, whether his grievance is genuine or not, that has to be tested. A person who has been teaching since 2015, you suddenly find that in 2023, she is not competent to teach you. I mean, it doesn't, it is not in consonance with common sense, and it rankles in the mind. What kind of a statement is this? Well, I cannot put anything more than that. I am appearing for the commission. My submission is that at the point of time when recommendation was made by the commission, she was fully competent to be appointed in that place because she qualified for everything. The length of the teaching, the doctorate, and LLM with 58%, more than 55%.
Yes, Mr.
May I just answer only one thing?
Just one thing. I believe the affidavit of the commission has been placed before your lordship. May I, at the cost of taking 2 minutes of your lordship time, indicate 2 pages from that affidavit. It has nothing to do with the commission or their action, but apropos to my submission, that what the department is facing with regard to these reminder letters to the college, kindly takes this order of my Lord Justice of the Honorable Single Judge has been placed, which starts at page 57. This order has been placed, which starts from page 57. Kindly take page 56 and takes respondent number 6.
Yes.
Respondent number 6 is the governing body of the college. Governing body of the college. Well, the next page, page 57, your lordship will find in that matter, college was unrepresented. So there was no one to take any point with regard to any eligibility criteria. College was not there. Number one. Number two, if your lordship in that same affidavit takes page 63, where the appointment letter, where the College Service Commission recommends the name of the appellant to the college. Kindly see towards the bottom left hand side. This same document is received twice. One by the new incumbent, that is the appellant, and one by the appellant as the teacher in charge.
Yes, Mr. Sannal, what do you have?
No. No, my lord, all these things placed before your lordships by the
Lordship,
state.
can you excuse me?
May I also take your
My state, your lordships.
No, Mr. Bose is here.
Your lordships will not find in the writ petition all the documents of the state.
We take up tomorrow, first matter. No, that has not been assigned to us.
Only one thing, my lord.
Well, my learned senior is appearing for? Well, someone who was appointed with 51% marks.
Whatever it is, where is Mr. Nag? Yes, where is your that affidavit taking over charge and everything you said? That you have given a copy to us? But no, this is commission. Affidavit on behalf of respondent number 3.
No, সকাল ঘাট থেকে নাম
Secondary.
গঙ্গা স্নান করে আসবে সালা।
পাচ্ছি না।
গঙ্গা
Yes,
স্নান
yes.
করে আসবে এটা ঘাট থেকে নামলে মহিলার ছেলে সালা।
No, where is that chart that you went,
কোন report?
page 16? Yeah. Page 31. Page 30.
Proceedings. First is proceedings.
Huh.
And
When did you take over charge?
October,
From whom did you take over?
the backup was supposed to be from the principal's office. Thereafter, on the When I read the I did see page 17.
No, who handed over you the charge?
Court.
Hmm?
Court.
No, you put the padlock, and you senior most teacher was appointed as the teacher. He was appointed.